Good morning, Mr. Hodge.
Good morning.
What case are you here on?
I'm here on behalf of State Auto for the CarePoint Physical Therapy assignee of Craig Knox versus State Auto case. It's case number 201908. I think mine got cut off actually because that's cannot be the full case number.
Okay, you're here for State Auto
Correct.
for John Lewis.
Yes, correct.
Okay, I was just wondering, you have Hackney Grover there, and we couldn't figure out who that was.
That would be correct. I'm on behalf of John here.
Okay. I'm just going to rename this. Okay, you're the only one here, so I'm going to put you back in the waiting room until someone else checks in.
Okay.
Okay?
Thank you.
Good morning, gentlemen. Judge will be with you in about 2 seconds here, okay?
Okay.
Thank you.
Good morning, gentlemen. CarePoint Physical versus State Auto Property Casualty. Appearances, please.
Morning, Your Honor. John Betts for Plaintiff, CarePoint Physical Therapy.
Good morning, Your Honor. Jason Hodge on behalf of State Auto.
Morning, man. So last time we spoke was 1st of September. We adjourned for discovery, I think.
That's correct, Your Honor. Attorney Paul Davis appeared on behalf of the defendant. He said he would respond to my client's discovery request quickly. And here we are 2 months down the road, and they haven't answered one interrogatory or provided one document. So I guess I need to file a motion to compel or a motion for default judgment. I'm not sure which.
I think you had a motion up on the 1st of September and you withdrew that based on those assurances.
That was against the plaintiff. The plaintiff had responded to the discovery request.
Oh, okay. All right. That was defense motion that got withdrawn.
Correct.
Okay. All right. So what's your pleasure? Tell me what you want to do.
So I just want to clarify real quick, Mr. Betts, are you saying you didn't receive the claim file? Because I do see where we sent that to you, but if you didn't receive it, we are more than happy to resend that. As for the discovery.
I don't have any sworn interrogatory answers nor the requested documents, as far as I know. So I guess if the court schedules a hearing for a motion to compel, we'll proceed that way. I
Okay.
can't get the cooperation from the defendant for some reason.
We have, I have requested that they sign the interrogatories. We have the answers ready to go. We're just waiting on the signature. I anticipate having that within the next 14 days. So
Well, that's the same
Happy to.
promise that we had 2 months ago.
Well, here's my suggestion. Why don't you contact Sandy, pick a motion date? And then we know on that date, we're going to do something. Either I'm going to make an order or the documents will have been exchanged.
Understood? That's fine.
Makes
sounds
sense.
good.
Anything else we can talk about today, fellas?
No, Your Honor.
All right.
Mr. Betts, I believe we have I'm sorry, Judge, I didn't mean to cut you off.
I'm just going to make a note in this file, then, gentlemen, that the plaintiff will schedule motion and we'll see where we go.
Thank you, Your Honor.
Okay,
All
thank
right.
you.
All right, so we're done on this one. Go ahead, Paul.
Mr. Betts, I think we have the other party for it says Wheeler versus Farmers or Pulse, but let me double check on that and make sure. It's CarePoint.
We have one case set at 9 o'clock and one at 9:15, which is the same attorneys and the same defendant, CarePoint Physical Therapy and Z-Ride.
Hopefully we can take care of them at the same time.
Sure.
Hello, good morning. How are you?
Macy, hi, Macy. Are you here on CarePoint versus Farmers?
I am, and also for Z-Ride.
Okay.
All right, so let's call the case. Case number 202765, CarePoint versus Farmers Insurance. Appearances, please.
John Betts for plaintiff on both cases.
Macy Abdallah for defendant Farmers.
All right, let's take care of Farmers and then we'll get to the other one. So where are we at on 2765?
Plaintiff filed discovery request. We have no cooperation from the defendant, so I guess I'm going to ask the court to order 60 days of written discovery because they won't cooperate apparently without an order.
All right, counsel, any objection to 60 days written discovery?
No, Your Honor, that's completely fine.
So we'll just set another pretrial?
Yes, Your Honor.
Fine.
All right, anything else on that file?
No, Your Honor.
All right, and what was the next one that you're both on?
Z-Ride Home versus Farmers, that's set at 9:15.
All right, let me find that file. Your appearances while I'm looking.
John Betts for plaintiff, the case number is 202766.
Macy Abdallah for defendant Farmers.
Thank you. And where are we at with this one, Mr. Betts?
Same situation as the other one. We would ask for 60 days of written discovery and come back for another pretrial after the 60 days.
All right.
Judge, I hate to interrupt, but they also have one at 9:30, and it's CarePoint Physical versus Z-Ride and Farmers.
Are you both on that one, or is somebody new covering farmers on that one?
No, aren't these the cases that we're here on? I thought those were them. Hold on, let me double check. John, are these the right cases that we're here on?
Is that
These are my only Z-Ride and CarePoint cases.
Injured party Anita Webb on that one?
Yeah, I've got 3 separate files. The one Paul is referring to is case number 202819.
No. No, I think the only case I have with Zosmer's office, or the only 2 cases, are the ones that we just resolved.
Yeah, this one shows that farmers, the 202819, farmers is represented by Peich Jeffrey Linden.
Yes.
Oh, no, that's not me.
Okay.
Wrong person then.
All right. So anything else on these 2 Z rides
No, Your Honor.
or farmers? So on both these files, we're going to put it out for 60 days written discovery only, and pre-trials will be scheduled after the 60 days.
Thank you, Your Honor.
All right.
Just
Have a
want
nice
to
day.
confirm. Thank you, Your Honor. Is the underlying claimant Johnson on those files?
Yes. Nicholas.
Okay. Thank you so much and have a good day.
You as well, counsel.
Thank you.
Mr. Betts, do you just want to, I'm going to put you back in the waiting room until we get someone else
Sure.
for you. Thank you.
Okay.
I have Guy Conti and John Ivanchek on Lakeshore Apartments versus Matt
Yep.
Seba.
Yep. Good morning, gentlemen. Lakeshore Apartments versus Seba.
Morning, Your Honor. John Ivanchik on behalf of the defendant.
Good morning, Your Honor. Guy Conti on behalf of the plaintiff.
All right, fellows, pretrial, what do you need from the court? Where are we at?
Same place we were yesterday. We haven't really done anything thus far. Probably some limited discovery on this case and maybe a motion for summary disposition date.
How much time do you need for discovery?
60 days, I think probably more than enough. And then do you want to set a SD motion date now or just wait till the end?
I'm not going to set any dates anytime, so you can contact
Okay.
Sandy and she'll give you your dates. But you can do
Okay.
that whenever you're ready.
That's fine.
Mr. Conti, okay with that? 60 days written discovery, motion date?
Sure, Your Honor. No problem.
All right. Anything else we can accomplish today?
No, I don't think so, Your Honor.
All right, gentlemen, either one of you have anything else on my docket today?
I don't think I do, Your Honor.
Your Honor, I have a 10:15, but I'm going to have substitute counsel there.
Okay. All right, gentlemen, stay healthy.
You too, Your Honor.
I'm going to find out who some of these attorneys are here on.
Sure.
Good morning, Mr. Ingber. Can you tell me what case you're here on, please?
Sure, 20-2355.
Michigan Education versus Donna Brown.
Right, it was maybe going to be adjourned. Let me just explain this to you. The defendant called my office last week explaining she was going to be having surgery and she'd be home recovering. I guess she sent a letter to the court. When I called yesterday, they said the only way they would adjourn it was if we could get them a stipend order. I was unable to reach the defendant to get permission to sign her name. Your ROA shows that it was going to be adjourned to December 15th at 9 o'clock, but we never got them the stipend order, so I don't know.
Counsel, I don't see it on the docket, Paula, do you? It looks like Sandy must have adjourned it.
It's on for 9:15, Judge, but that was the letter that I brought into you this morning and asked if we could adjourn it, and you said yes.
Okay.
Okay, I did not know, so I wanted to check in. Okay, that's good. Thank you very much. I'll see you on the 15th then.
Stay healthy.
Thank you.
Thank
You too.
sir.
Thank you much.
Okay, Hal Burke is here on Beaumont versus Jaeger, but the other side is not in yet. So I do know who that is.
Okay.
I'm going to check Alice Fabzuski. Good morning.
Good
Miss-
morning.
Is it Fabuzowski?
Yes, thank you. Fabashevsky. I'm here for Michelle Endres and also two other attorneys from
So
my.
give me some case names, counsel.
Sure. Grossbeck RS versus Auto Club. We represent Auto Club. And then I have CarePoint Physical Therapy versus Farmers. Z-Ride Home versus Farmers. Those are both scheduled for 9:30. And then at 10:15, I have a United Lab RX versus Nationwide.
The farmer's one is John Batts, Judge. Do you want me to bring him in first?
Not until I locate that file, which I don't seem to have.
Okay.
Okay.
But Z-Ride versus Farmers.
Yes.
CarePoint and Z-Ride versus Farmers. That's the one
All four of those do have John Betts as
All right.
on the
So-
plaintiff counsel.
Grossbeck, CarePoint, what were the other two, counsel?
Z-Ride Home and United Lab RX.
Z-Ride Home is with CarePoint. That is 202819.
Right, I got that one, and I got Grossbeck. United Lab,
Correct. Versus Nationwide.
yeah, and there was a fourth one. And you keep telling me Z-Ride, but that's the file I've already pulled.
Oh, the fourth one then, you have the CarePoint?
That's the same file.
Okay.
That's
very
CarePoint
good.
versus
So then
Farmers
it's-
and Z-Ride.
Okay, thank you. That was the confusion. I apologize.
Okay, so there's three files,
Correct.
and they're all John Betts on the other side, I think.
Correct.
That should make it easy. Let's bring Mr. Betts in. All right, Mr. Betts,
Good morning.
on United Lab RX versus Nationwide, your appearances, please.
John Betts for plaintiff.
Alice Fabashevsky for defendant.
All right, Mr. Betts, where are we at on this one?
Well, we've got, I have three cases with Anselmi's office. This is one of them. One set at 9:15, one 9:30. This one set at 10:15, but that's fine. On all the cases, we're in a similar situation. The defendant has filed 172 affirmative defenses, which is absolutely crazy. I think they're trying to make a joke of the legal process. I asked them for the documents that support their claims, and they have provided nothing. So I think what we need is 60 days of written discovery so I can have the opportunity to demonstrate to the court that they've filed frivolous defenses, which will enable my client to recover not only its claim, but reasonable attorney fees by statute.
So same situation on all three of these files. You're suggesting 60 days written discovery with another pretrial?
That's correct, Your Honor. That's what I think is a realistic way to proceed on all three cases.
All right, counsel, you agree?
Yes, Your Honor, we'd just like to get discovery.
Okay. Written discoveries on all three of these files. We'll do written discovery 60 days with a pretrial. Hopefully the clerks will get them all scheduled the same day. If they don't, call us so we can make that happen.
Great. Thank you, Your Honor.
Thank
All
you,
right.
Your Honor.
Folks, anything else on these three?
Oh, Your Honor, I have one more at 10:30 with
Okay.
another attorney.
Okay. All right. We'll stick you back in the waiting room then.
Thank
Mr.
you, Your
Wesky,
Honor.
thank you. Stay well.
You too. Happy Thanksgiving.
You too. Thank you.
I'm going to bring in Sarah Clemens and find out who she's here for.
She's on Midland Credit
Yeah, I
versus,
was just gonna say that. I'm putting her back in because there's nobody else here on it yet that I can see.
is Hal Burke a defendant?
No, he is an attorney on Beaumont versus Yeager. But
All right, we're still
he's the
waiting for
only-
Yeager then. Do you know who Edward is?
I'm gonna find out in just a second.
Good morning, Miss Francis.
Good morning, Judge. How are you?
Just living this Zoom dream, counselor.
Can you tell me what case you're here on, Miss Francis, please?
Yes, I'm here on Midland Credit versus Sarah.
Clemens, who is in our waiting room. So we'll bring her in and take care of some business.
Thank you. I tried to put my case number and everything in my name, but yours had the link instead of allowing me to do it through my Zoom, so it wouldn't
Okay.
let me change it.
All right, Miss Clemens, can you hear us?
She's not connected, Judge.
Judge, we didn't get her answer in this case, so I'm not sure what it said.
Looks like it came into the court on September 14th. Just a one pager. This is my debt. Do wish to see a payment plan is available. Got fired after 3 years on the job because of business closed.
I just sent her a chat to please
Yeah.
connect her audio.
In essence, financial hardship, but I do have a phone number. Paul, I'm going to give you that phone number if you want to try to call her. 734-548-1534. It sounds like maybe Miss Francis would want to go into a breakout room.
Yes, Judge.
And if we can't get her connected, maybe a phone conversation between the two of you, and then you could get her on your speakerphone or whatever. We'll get something done.
It looks like she might have just connected.
Miss Clemens, can you hear me?
Hi, Miss Clemens. This is Paula from Judge Oakley's office. Go ahead and turn on your audio. We've got you pulled up on the screen. That's okay. Just unmute
Awesome.
is all
That
you have
makes
to
sense.
do.
I'll take it.
Uh-huh. Bye.
Maybe the phones are down.
She's going to
Maybe the
unmute.
phones are down.
Can you hear me?
Yes, thank you. Good morning.
Okay, thank you. Sorry. Good morning.
You're all right. Midland Credit versus Clemens Counsel, your appearance for Midland.
Good morning, Your Honor. Navjot Francis on behalf of Plaintiff's Attorney of Record P72322.
All right, Miss Clemens, I'm looking at your answer. Looks like maybe it would benefit you to have some conversation with counsel to see if you can work out some kind of a consent judgment with payments.
Okay.
All right, so Paul is going to put you ladies in a breakout room so you can have some private conversation.
Thank you, Judge.
Good luck.
I'm gonna
You want to see
find
who
out.
Edward is?
That's what I'm doing right now.
Yeah. Oh, probably on McClure versus Davis.
Edward?
Yes. Can you hear me?
Yes. Can you give me your full name, please?
Yes, Edward Alvin McClure.
Okay. We don't have the other party yet, so I'm going to put you back into the waiting room, okay?
Okay, thank you.
Thank you. Okay, I renamed him, so. You want me to bring Mr. Burke in and let him know that his client or the defendant hasn't checked in yet? Or
Yeah,
is
which one is he on?
He is on Midland, excuse me. Wrong page. Beaumont versus Yeager. Good morning, Mr. Burke.
How are you doing? Can you hear me?
Yeah, Mr. Burke, we do not have the other party in yet, so I just letting you know, we know you're there, but I'm gonna leave you hanging out in the waiting room just until we know what's going on, okay?
Okay, thank you.
Thank you. Michael Riker. Oh, I have the other party for Ed McClure. It's the attorney, McClure versus Davis.
Good morning.
Good morning.
All right, good morning.
Good morning.
McClure versus Davis. Counsel, your appearance for Mr. Davis.
Good morning, Your Honor. Michelle Riker Simone on behalf of Thomas Davis.
And good morning, Mr. McClure.
Good morning, sir.
Mr. McClure, today's a date and time set for a pretrial. A pretrial gives me an opportunity to get some information about the file so we can put it on the calendar and move it towards, hopefully towards an ultimate resolution. Understood?
Yes, sir.
All right. So counsel and I are going to have some conversation. We talk our own language, but I'll do my best to translate for you so you know where we're at.
Okay.
All right, counsel, where are we at on your end? I see you filed an answer.
Yes, Your Honor, we did. Actually, since we filed the answer, we had been attempting to reach a resolution with Mr. McClure. Unfortunately, the parties are not there yet.
Okay.
So
Do you
I
think?
probably,
Do you think if I refer you over to Wayne County Dispute Resolution, it would help?
I'm not sure.
Okay. Or we could just set it for a motion or trial, whatever, whatever we got to do.
I mean, I would assume that you're talking about like an ADR, like a mini case eval type thing.
Exactly. Yeah. Yeah. Mediation center.
I would say that would be helpful.
Yeah.
Then I would say, yeah.
It's cost free. So.
Yep.
Okay. All right. Mr. McClure, here's what I just heard from counsel. She thinks there's still a likelihood that we could settle this case without need to go to trial. My suggestion is that I send you to the Dispute Resolution Center, which would be by Zoom. You don't actually have to drive anywhere. They're doing them by Zoom, just like we are, to see if they can help you folks reach a resolution. If not, then we can put it back on my docket for either a motion date or a trial date. Let me earn all the big money that the state pays me.
Right. Okay.
Do you understand? Do you understand the process where we're at?
Yes, sir.
All right. And are you amenable to engaging in that mediation process to see if it'll help the parties resolve this?
I would just rather keep it straight on track the way it is going now, sir.
Okay. Let me, and sir, I'm not going to force you to go to mediation, but let me tell you why I would really strongly encourage you to do so.
Okay.
If I understand the fact scenario, you and Mr. Davis are neighbors.
Right.
Are you planning on moving anytime soon?
No.
Do you know if he is?
I don't know.
Okay. Here's where I want you to hear my heart on this. The court system does a real good job of making decisions and making people angry. The way, and I'm not trying to be funny. I've been in this business for 30 years. The system works real well at listening to your claims, listening to the defense Mr. Davis puts on, and then making a decision.
Right.
What we're not real good at, the process doesn't do a real good job on resolving the differences that are not particularly the legal issues. So if you folks are going to be living together, and trust me, I've been around a little while, I know that there's nothing worse than bad neighborhood relations. So if I send you to the mediation center, they might help you folks work something out. So not only can we resolve the legal issues, but you can coexist next to each other for the next 20 years in peace.
Right.
And that's real important to me.
Yes, me too, sir.
Yeah. Because I'm not planning on going anywhere. And if you folks aren't good neighbors for the next 20 years, I'll probably be dealing with your crap for the next 20 years. You hear me?
Yes, sir.
So once again, I am not going to hold it against you. I'm not going to put a little mark next to your name on this file and say, this guy refused to go to mediation, so I'm going to gig him at trial. I'm not going to do that, but I would strongly encourage you, because really all you've got to lose is some time. It's not going to cost you any money. So I would strongly encourage you to engage in that process, at least get it started. If you think it's a joke, if you think there's no way it's going to help you, then that's fine. But I would really like to see some energy go into maintaining a positive neighborhood relationship, not just resolving whatever legal issues are in front of me with this file.
Okay. Yes, sir. We can try it, sir.
Thank you. I feel like I've earned my keep today. All right, so what I'm going to do is I'm going to make a note in the file. And Mr. McClure, I'm going to let counsel kind of take the reins on this, because she knows the ins and outs of this.
Right.
So my civil department will, I think the way they're going to do this is they're going to send out a notice basically with the information for the Neighborhood Dispute Resolution Center. And we'll set an in-house review on our file so things don't fall through the cracks.
Okay.
My understanding, and don't take this as my guarantee, but my understanding is that the center's pretty quick. They're probably going to jump on this fairly quickly and get you scheduled. All right. Any questions? Counsel, Mr. McClure, any questions?
No.
The only question I would have administratively, Your Honor, I understand that you are referring us to the Resolution Center. Is it possible that we could get a short period of discovery in this matter as well?
Sure.
Just in the event that the resolution doesn't work?
30 days, plenty of time?
I'm thinking,
If you need more.
could I do 60 just because holidays are coming up?
Yeah. I'm not thinking.
Yeah. Well, unfortunately,
30 days right now doesn't really mean much.
that would be Christmas Eve, Your Honor.
Right. All right. So I'm going to explain that to Mr. McClure. Mr. McClure, what council's asked for is discovery, and discovery is just a legal way to say exchange of information. So council, correct me if I misspeak. Probably what's going to happen is Ms. Simon is going to send you a list of questions, and she wants you to answer those questions under oath. She might send you a request for documentation. For example, she might say, look, in your paperwork, you allege that the estimates for the damage cleanup were $1,000. Can I see the estimate? And she might want you to send a document. And that exchange of information, sir, is supposed to be a two-way street. So if there's anything that you think counsel or Mr. Davis has by way of questions or answers to questions or documentation, you can ask for those things through Mr. Davis's attorney. You understand that's just an exchange of information. We're going to do that. We're going to have that open for 60 days. In other words, what my clerks are going to do is just calendar this so we don't forget about you folks. You're going to set up a mediation with neighborhood dispute resolution, and you're just going to make sure between you and counsel that mediation is not 2 weeks down the road, because you want to have time to exchange this information before you have your mediation. Is that making sense to you, sir?
Yes, sir.
All right. Any questions about the process, Mr. McClure?
No, I would say the only thing that I would say is everything that I have, they should have also, and the court.
Okay. I'm just giving examples. There might not be any documents that counsel's looking for. She might be perfectly in agreement with what you just said. All right. Anything else?
No, not on my side.
All right.
No, Your Honor, I don't believe so. Thank you.
I wish you folks good luck. Stay healthy and enjoy your holidays.
Thank you. You too.
Thank you. You too, Your Honor.
There's much to be thankful for, even if we're still doing Zoom.
Actually, it's a lot easier, Your Honor, because I don't have to get in the car and drive.
No, and if I was on your side of the bench, I'd probably think the same. But up here, I don't like it.
Well,
I miss my people.
Sorry. Well, and I miss people too, but it allows me to be a lot more places a lot faster too.
Yeah, Zoom, I've been saying for months now, Zoom has actually solved the age-old problem of a trial attorney of being in 3 places at the same time.
Yes, because you can do one on your laptop, one on your phone, and one
I've
on your
had
desktop.
it happen. I've seen the attorneys with all their electronics in front of them and just juggling them like clowns juggling plates.
Exactly.
All right. Have a good day.
Thank you.
You're welcome, sir.
Judge, I agree. I like it in person better.
Yeah, I told one of my clerks a long time ago, at heart, I'm an entertainer and I'm used to having 30 people in front of me every morning. I don't have an audience anymore. It's not as much fun.
It's also hard when you're just sitting in a waiting room and you don't know what's going on. And I've,
Well, you know, we just had a conversation yesterday, couple of judges, because my understanding that a lot of judges are like just bringing everybody into the meeting, just as if it was a courtroom full of people. Judge Green's doing that to a certain extent. And that the thought of that just drives me nuts, because then I got to try to figure out which one of those little tiny postage stamp people I'm talking to. I might try it, but I'm not ready for it yet.
I like the way like some courts will at least bring you in and check you in if they have
Right.
a whole bunch at one time.
Right.
But some courts just leave you in the waiting room. And I've been in the waiting room for 3 hours before, or
Yeah.
one day I
I've
was
heard
there
those
for
horror
4.
stories. Yeah.
And then
yeah.
it's like, you don't know if the court's closed or what's going on.
Well,
Like,
and an attorney told me recently that what she does is she gets in the waiting room and then she puts the YouTube up too, so she can see what's actually happening. So she kind of gets a flavor for where things are at.
yeah, it's just
Yeah.
some of the courtrooms you can't find their YouTube.
I would imagine that is a problem. Yep. All right, Ms. Clemens, can you hear me?
Yes, I can hear you.
All right, we're back on the record with Midland Credit. Did you ladies have any success?
We did, Judge. We have agreed to a consent judgment for the full balance, and defendant will make payments of $100 a month for 3 months, beginning January 1st, 2021. And I'm not sure how Your Honor is accepting consent judgments.
Here's what I would suggest. Did you have, Ms. Clemens, do you have an email address?
Yes, I gave it to
Did you
her,
get
but
it?
I do have
All right.
an email.
Here's what I'm going to suggest. Counsel, you put together the consent judgment, email it to Ms. Clemens. Ms. Clemens, you're going to read that, and if you're okay with the way it reads, you're going to send back an email to counsel that says she can sign your name. She'll sign her name for the plaintiff, your name, with your permission. She'll send that to the court by email. I'll sign it, and we could have this back to you people in a couple days. Ms. Clemens,
Okay.
that makes sense?
Yes.
Okay. Now, one thing I want to make sure, Ms. Francis, I'm sure you did, but I just want to make sure it's on the record. Did you discuss with Ms. Clemens what this consent judgment will do as far as actions it will or will not stop collection actions?
I did not.
Okay, let's do that. So I'm going to tell her what it's going to do, and you tell me if I misspeak.
Okay.
All right. All right, Ms. Clemens, as long as you've got this consent judgment, I know Ms. Francis and her firm, so I'm pretty sure they're not going to do anything to collect this as long as you're making your payments, other than they'll probably go after any state income tax return.
Okay.
But I need to let you know, there's nothing about this consent judgment that legally prevents them from garnishing your bank accounts, going after, sending the court officers out to seize personal property, doing all those other things that a plaintiff that holds a valid judgment can use the law to collect their debt.
Okay.
Understood?
Yes.
Okay. Now, Ms. Francis, did I get that right? Or would you like to correct any of that?
I am not sure if this firm refrains from bank garnishments. I will let them know what you stated on the record.
Okay.
But I'm not exactly positive if they will refrain from that. But
well, let's do this then. Let's do this because from what I got out of Ms. Clemens' answer, she needs some breathing room. So why don't we do this? And you can strongly suggest to your client that I came up with the idea.
Okay.
Why don't we do $100 a month for 6 months? No other collections activity will take place, with a review at plaintiff's option. So at that point, if Midland wants to be able to go after something more than just $100 a month, they can motion it up and we can have a conversation.
I would ask that we at least be able to do tax garnishment still.
I'm okay with that because that's kind of the norm. Ms. Clemens, you understand that?
Yes, I do. Thank you.
So other than them coming after your tax returns, at least for 6 months, you know that as long as you're paying $100 a month, you don't have to look over your shoulder for Midland.
Thank you. I appreciate
Okay.
it greatly.
Now here's what I'm gonna give you a little advice you didn't ask for. Most collection situations, as long as the money's coming in like clockwork, they kind of forget about you.
Okay.
It's if you're paying late or you miss a couple payments, now they start getting nervous and they start looking at what their other options are.
Right.
So I'm not guaranteeing that as long as you make all your payments, you won't have to worry about any activity after 6 months. I'm just saying that certainly puts you in a better position to just keep running the $100 a month.
Sure. Thank you. I appreciate it.
All right, ladies, is there anything else?
Judge, did you say we have to motion up a review after 6 months, or does the payment plan just stop after 6
No,
months?
it'll keep running unless you file a motion.
Okay.
So if your clients are satisfied with the $100 a month, just don't do a thing except cash the checks. But if after 6 months they want to get a little bit more aggressive, then file a motion. We'll have that conversation.
Okay.
Okay.
Thank you, Judge.
Ms. Clemmons, do you have any questions, ma'am?
No, I do not. Thank you.
You're welcome. Good luck.
Thank you.
Ms. Francis, anything else with us today?
No, Judge. Thank you. Have a great Thanksgiving.
You as well. Stay healthy.
Thank you. You too.
Paul, who do you got?
Gibson is a defendant, nobody on the other side. I'm going to bring Michael Beach in and find out what they're here on. I can't find it on the docket. And then I do have two attorneys. I don't know who Brian Groan's here on. I'll find out in just a second. Good morning, Mr. Beach. Mr. Beach? I can't hear you. Do you have your audio connected? I'm sorry about that. I can't hear you.
Hello?
I can hear you. Can you tell me what case you're here on, please?
I am on credit acceptance versus Wilson Buyers, 201807.
Let's see. Okay. Are you here for credit acceptance?
That's correct.
Okay, we don't have anybody from, well, we don't have Mr. Byers in yet. But so I'm going to put you back in the waiting room. Just know we know you're there. As soon as Mr. Byers checks in, we'll bring you back in.
How long generally do you give them to check in?
He normally gives them 30 minutes.
Okay, thank you.
Uh-huh. Bye. Good morning, Mr. Groan.
Good morning.
Can you tell me what case you're here on, please?
I am here on the Midland Credit Management versus Lily Spikes.
Okay, just putting that in there so we know.
No problem.
Okay, she has not checked in yet, so I'm going to put you back in the waiting room.
Okay.
And as soon as she checks in, we'll let you know.
I appreciate it. Thanks.
Thank you.
Hey, Sandy, can you hear me?
Yes.
Would you do me a favor and send one of those set of young legs down here to grab a file?
I will do that.
Thanks.
Judge, we still have Mr. Burke in the waiting room on Beaumont versus Jaeger. Do you want to bring him in and default that one, or?
Yeah, bring him in. It's going to be a minute. I'm going to finish a note.
Okay.
Put a mask on.
Mr. Burke?
How are you? Yes.
Good. Hang on one second. Judge will be right with you, okay?
Thank you. Yeah, you guys usually run it.
And this is Beaumont versus Jaeger? Would you do me a favor? These can go down there. Would you contact his?
I can hear you. Can you hear me okay?
Yes, sir. Judge will be right with you. He's talking to someone on the side.
All right. Calling Beaumont Health versus Jaeger, case number 198465. Counsel, your appearance, please.
Yes, Your Honor. This is Hal Burke. I'm an attorney for Beaumont Health on this case. I didn't know if Miss Yeager joined us or not.
Unfortunately, no.
Okay.
In my notes show that we did have a pretrial on September 1. Ms. Yeager was in at that point. We adjourned for discovery. No, we adjourned for some discussion.
You're absolutely right. We have not had any productive conversation with her.
All right. And do
I don't know
your
if you-
notes say when the last contact was?
The last contact I had with her directly, is that what you're asking?
Yes, sir. Yes, sir.
Not since that last hearing in front of you.
All right. What I'm going to ask you to do then, because the notice asked her to be in our waiting room 15 minutes prior to the scheduled date or scheduled time, scheduled at 9 o'clock. So it's almost an hour now and she hasn't been in. So I'm going to ask you to submit a default judgment under the 7-day rule. Give her a chance to come up with a good excuse why we didn't see her smiling face on Zoom today.
I will get that to you. I appreciate it. Thank you, Your Honor.
All right. Stay healthy.
You too. Thank you.
That's all we've got with both sides, Judge.
All right. If you're keeping track on your docket, GA Business, West Side, the very first.
Yeah.
When you're done, we just want to explain something. Okay. Mr. Beach, good morning. Your appearance for credit acceptance, please.
Good morning, Your Honor. Michael Beach, B-E-A-C-H, for credit acceptance.
All right. I've got Mr. Wilson Byers on my speaker phone. Mr. Byers, can you hear the attorney?
It's kind of low, but I can hear.
Okay, I've turned up my volume, so that'll probably help. And today's the date and time set for a pretrial. Mr. Wilson Byers, a pretrial is an opportunity for me to get information about the file so that hopefully we can put it on my calendar and move it towards an ultimate resolution. Understood?
Yes.
All right. Counsel, where are we at from the plaintiff's standpoint on this file?
Your Honor, I have an idea what the defenses are. The answer is officially, I never received a copy of an answer. But
Counsel, we've got a handwritten one sheet that came in on September 15 that we took as the answer. We can get that to you today.
Okay, thank you.
Make a note.
I think the general gist of what the phone call was at least he was saying something about the car wasn't operating or had some issue. So I'm not sure if there's more to the answer than that.
Well, let's find out. Mr. Wilson Byers, what's your defense to this claim of almost $7,500 from credit acceptance?
The car, I only had it for 45 days. The engine blew in it. I even got the oil changed when I bought the car. I don't know why. I don't know why it happened.
Okay, counsel, catch that?
I heard that, Your Honor. Yep.
Okay. So from your standpoint, counsel, where do you want to go with this?
I guess the best thing maybe throw in 90 days of discovery. We can send some interrogatories, requests for admissions out.
All right, written only, correct?
Only written, yes.
Okay, and what do you anticipate, a motion after that?
I do anticipate a motion.
Okay, all right, Mr. Wilson Byers, let me translate. Attorneys tend to speak our own language, so let me translate. Counsel's asked me to put a time period on this for discovery, and all that means is an exchange of information. So counsel's going to send you a list of questions and ask you to answer those questions under oath. He may send you a request for documents. So for example, I don't know, some contractor, paperwork or something like that they don't have in their records that they think you might have. They'll ask you to share that if you do have it. Discovery is a two-way street. So if there's any questions you have that you think credit acceptance can answer for you that'll help you prepare your defense, you can ask those questions of credit acceptance through their attorney. Understood?
Yes.
All right. So what we're going to do is I'll make a note in the file that we're going to set that time period for about 3 months out to give you fellows a chance to exchange information. Counsel's telling me that after that exchange of information, he's probably going to file a motion. And a motion, once again, we use our own language. A motion is just another word for request. So summary disposition, I assume, Mr. Beach?
That is correct, Judge.
All right. So what counsel anticipates at this point is at that point, after our discovery, after our exchange of information, he'll file a request asking me to give credit acceptance a judgment against you for that $7,400 number. And his argument's going to be that there are no important facts that are in dispute. And based on the law that applies to this legal matter, they're entitled to that judgment. You'll get a written copy of that motion or that request. You'll have a chance to respond in writing. You'll also get a chance to respond at another Zoom hearing down the road. Now, hopefully we'll be live, but probably be Zoom. And at that time, I'll listen to what he's got to say. I'll listen to what you've got to say, and I'll make a decision. If I agree with his argument that they're entitled to a judgment, then I'll issue the judgment and they'll have a binding court document that says you owe credit acceptance that money. If I disagree with their argument, in other words, I think their argument is not a strong one, at that point, I'll deny their motion and we'll move forward with the court process. And at that point, usually we set a trial date. Do you understand the process, where we're at and where we're headed?
Yes.
All right, counsel, anything you want to add or correct that what I told Mr. Wilson Byers?
No, you've covered it fairly well. That's fine.
Right.
One thing, Judge, before we leave, I'd like to verify a phone number for Mr. Wilson Byers, if I could.
Yeah, I just called him on 313-482-5224.
Okay, very good. That's the number we have. That's fine.
And that's the best number for you, sir?
Yeah.
Okay. Do you have any questions, Mr. Wilson Byers?
Well, I'm wondering because I'm just wondering if I should have sued the car dealership for the money because I don't know if I have any. I don't know if I have any thing to do with credit acceptance. I don't know if I'll be able to cancel this debt.
At the risk of sounding like I'm giving you legal advice, I would strongly encourage you to get some legal advice. I would talk to an attorney about this situation. If you can't afford one, and usually you can talk to an attorney for an initial consultation without paying for it. But if you can't get an attorney that will listen to your story and give you some advice without paying them big money, then I would suggest you try to talk to legal aid. You've got 90 days to do that, so you can probably make contact with an attorney that can hear your story and then give you some legal advice.
Okay.
Anything else, sir?
No.
Counsel, anything else we can accomplish today?
Nothing further, Your Honor. Thank you.
All right. Mr. Wilson Byers, I'm going to wish you luck and hang up on you. Have a nice day.
Thank you.
You're welcome. Counsel, you have anything else with us today?
Nothing further, Judge, but you guys are gonna mail out or email. You can email it to me if you want to, copy the answer.
I'll make a note of that. And I'm assuming your email in the Bar Journal is correct.
That is correct, Judge.
All right, I put a note in the file, so one of the clerks will take care of that. Thank you.
Okay, thank you. Have a good day.
You as well.
I have Mark Sadecki and Patrick Haynes, both sides, outdoor versus RKJ
Yep.
and Bereka. I'll bring them both in.
Judge, I just got a phone call for the first one on the docket today. They are going to file a dismissal.
Okay. Yeah, that's the one I asked Emily to email or send them your email address. You must have
Thank you.
talked to the defense attorney because I talked to Mr. Mueller. Okay, thank you. All right, I think everybody's connected. Outdoor Experts versus RKJ. Gentlemen, your appearances?
Patrick Haynes on behalf of Outdoor Experts.
Mr. Sadecki, it looks like you're still muted, sir.
Well, I'm sorry, Your Honor.
No problem.
Mark
Your
Sadecki.
appearance,
Mark
please.
Sadecki
Awesome.
Mark Sadecki
Okay.
on behalf of the defendant.
All right, gentlemen, last time we spoke was way back in June. Looks like you folks were going to talk to the Dispute Resolution Center. I'm assuming I'm talking to you again today, so that didn't work.
Correct.
All right, so are we ready for a trial date, motion date? What do we need?
I think a trial
Probably a trial date.
All right. What do you think, fellas? You want to try this one by Zoom?
I'm gonna have to ask my client about that, Your Honor. The hotel, without getting into any of the discussions, Your Honor, the hotel's closed due to the pandemic. There's serious financial issues, you know, you can imagine on a $20 million asset.
Right.
We gave it a shot to try to resolve it, but it didn't work. So bankruptcy is probably going to be a likely option for them at this point. But
you fellas tell me how you want to handle it. I can put it in a note in the file that we're going to set this for a live bench trial, which means nothing's going to happen until after the first of the year. Or I can just set it for an in-house review with the idea you guys are going to talk to your clients and get back to me. If we can do it by Zoom, we can probably schedule it before then.
Yeah, Zoom is fine with me. It doesn't matter.
let me talk to my client. Your Honor, I'm trying to take the last 2 weeks of this year off because I've had a week,
Okay.
a 2020 week after week. So, but let me
So I'll
talk to
just
my
set it
client.
for an
I'll
in-house
get back to
review
you.
within 30 days, and we're just waiting for you to let me know if defense wants to do a Zoom or wants a live.
Okay, thank you, Your Honor.
Your Honor, do you have on your website any particular protocols for your Zoom trials that we should be concerned about?
Basically, just the biggest problem we've got is exchange of documents.
Right, that's why I'm asking.
And I think everybody's in the same boat. That's the biggest problem with the Zoom trials. So I would suggest that anything either one of you want to use as exhibits, they're emailed to me, my clerks, they're emailed to the other side ahead of time. So we all have documents in front of us, so we're not trying to look at them and exchange them on the screen. But I mean, it's a brave new world, right? We're all learning as we go.
That's true.
Yeah.
Pat, yeah, I've done a few of these, not by Zoom, but just by DEPs. And how about if instead of plaintiff, why don't you use letters? I'll use numbers, and then we can coordinate that way. We might have duplicate documents, but at least they'll all be marked and identified.
All right, so that makes sense, fellows. I'll just set it for an in-house review with the idea Mr. Sadecki will get back to us with an answer.
Okay.
Correct, Your Honor.
Sounds good.
Okay. All right. Thank you, gentlemen. Stay healthy. Enjoy your holiday next week.
You did ask us to report on Wayne County's dispute resolution services
Yes.
when we were last
Yes,
together.
thank you.
Mark and I both tried probably over a 2-week period to reach them with absolutely no success.
Really? That's disappointing.
Yeah, we went to a different county and got it done, but I just,
Okay.
you wanted to have a report.
Yeah, thank you. That's very disappointing.
Yeah, it was.
Yeah, they were totally MIA.
Okay. All right. Well, sorry about that, fellas.
All right.
All right.
Thanks, Judge.
Stay healthy.
Thank you.
Thanks.
Happy holiday.
I'm going to find out who Mark Herzog is.
Judge, I have Lily Spikes. She's called in and given me a phone number because she can't get on Zoom. She's from Midland Credit versus Lily Spikes at 9:30.
Yeah, phone number is?
734-391-7828. She also gave me another one, 734-307-8880.
All right, thank you. When we're ready for that, we'll call her.
Mr.
Thank you.
Herzog, can you tell me what case you're here on, please? You need to unmute. Thank you.
Yeah, I just did that. I'm here on the 1015 Citibank versus John Gibson.
We do have him in our waiting room. I'll bring him in.
Okay.
You ready, Judge?
Yeah, do we have an attorney on Midland versus Spikes?
Yes.
Okay, let's bring them in after Citibank.
Okay.
All right, Citibank versus Gibson. Counsel, your appearance, please.
Good morning, Your Honor. Michael Herzog on behalf of the plaintiff.
And you are John Gibson. Can you hear me okay?
Yes, sir.
Good morning, Mr. Gibson.
Good
Mr.
morning.
Gibson, today's the date and time set for a pretrial. Gives me a chance to find out some information about the file, so hopefully we can put it on a calendar and ultimately move it towards resolution. So, Mr. Herzog, where are we at on the plaintiff's end?
We filed a pretrial statement. The amount of money owing is, since of the complaint, $30,465. It's a non-jury trial. It is a credit card with Citibank, and we would request 60 days discovery would be fine.
All right, what do you anticipate? Trial date after that or motion?
I anticipate a motion first, Your Honor.
Okay. And Mr. Gibson, I'm going to interpret all this. I know we talk our own language sometimes.
Please. I'd appreciate it. Thank you.
All right, so discovery is just a fancy legal word for exchange of information. So, Mr. Herzog, I'm gonna tell Mr. Gibson what you're going to do, and then you tell me if I misspeak.
Okay.
Counsel's probably going to send you a list of questions and ask you to answer those questions under oath. He might also ask you for some documents. If he thinks you've got documents in your possession that, you know, is a missing piece of the puzzle on their end, he might ask you for that document. It's supposed to be a two-way street, this exchange of information. So if you have questions for Citibank that will help you put together your defense of the claim, or if you have documents that you think Citibank has that will help you put together your defense, you can ask those questions or ask for those documents from Citibank through Mr. Herzog's office. You understand that, sir?
Yes, sir.
All right. And then Mr. Herzog and I also discussed what would happen after that 60-day discovery period. Mr. Herzog tells me that he's thinking he's probably going to file a motion for summary disposition. Once again, motion is just the word we use in the legal community instead of request. And what that means is he's going to request of me that I give him a judgment against you on behalf of Citibank because there are no important facts that are in dispute as they apply to this case. And the law that applies to this case puts them in a position where they should get their judgment. If I agree with that argument, then I'm going to give them the judgment. We're going to go forward with, it's just a collection stage at that point. If I deny their argument, we're going to move forward. And at that point, usually what we do is schedule a trial. Now you're going to see that argument in writing. They'll file that with the court. They'll send a copy to you. You can respond in writing, and you'll also get a chance to respond orally because we'll get together for a hearing on that motion. Maybe Zoom, maybe live. Hopefully it'll be live by that point, but I'm not making any guarantees. So you understand where the process is at, where we're at now and where we're headed?
Yes, Your Honor.
All right, counsel, would you like to clarify or disagree with anything I said as far as explanation?
No, Your Honor, I think you said it perfectly clear.
Okay. So I'll put a note in the file. We'll adjourn this for 60 days out. Within that time frame, Mr. Herzog will contact the court clerks and pick a motion date so he knows when he's going to send his motion out so you get it and I get it. Anything else we can take care of today, gentlemen?
Your Honor, are we to submit an order of scheduling order purposes, or the court will do it themselves?
I'm not worried about a scheduling order. If you want one, then you send one to me.
Okay.
Everything's on the record, so I'm comfortable with that. If you want an actual scheduling order, then prepare one and we'll take care of it from that.
Thank you,
Mr.
Your
Gibson,
Honor.
do you have any questions?
I just have one, Your Honor. We are working with a debt resolution company right now,
Okay.
and they're, from what I'm being told by them, that they are already talking to Citibank to get a resolution on this. So, I mean, I haven't heard any mention of that at all.
Let's
why not?
find out if Mr. Herzog knows anything about that.
I do not, Your Honor, but that company is certainly welcome to contact our office with the WWR number that's on our pleadings at the top and ask for either Dan Best or Jeff Beers. And we'll be happy to talk to him.
All right, Mr. Gibson, I have 2 comments on that. First of all, I've been doing this a long time, and I have talked to a number of people in your position that think they've got the assistance of a debt collection agency. In the vast majority of those cases, I don't see where the debt collection agency has ever helped that person at all. So I'm just telling you, be cautious of putting all your eggs in that basket. Secondly, at this stage in the game, because there's litigation going, they need to communicate with the attorneys, not Citibank directly.
Your Honor, I have right here in front of me the papers that we sent to the attorney, and we have the receipts where we paid. I have them right here where we paid that we sent the paperwork.
You've made payments to the attorney since this case was started?
No, Your Honor. What I'm saying is paperwork that the debt consolidation people said that we had to answer and respond to them. The lawyers, I've got it all right here in front of me where, you know, that we've done the paperwork, we filled it out. We've sent them, we got receipts where we sent it certified mail. So I'm having a hard time understanding, you know, why he wouldn't believe that he got it. We sent it right to the address.
Okay, what did you send? I'm confused as to what paperwork you sent.
Okay, according to Beyond Financial is the ones that we're working with.
Right.
When we received the complaint, their attorneys helped, or I'm assuming that's what they told us. They helped us with in answering these.
Right. Yeah, your answer, I'm sure your answer made it to council because it made it to the court.
Oh, okay.
But other than the answer, Mr. Herzog, correct me, other than the answer, Mr. Herzog hasn't been contacted by that agency to talk about a settlement.
I have not picked up this file this morning, but as I said before, the answer that was filed by Mr. Gibson does look like it was drafted by somebody with some legal background.
Right.
Yeah, some knowledge, some format knowledge. But we're happy to talk to any debtor regarding settlement of a case at any time.
Yeah. And Mr. Gibson, the other comment I wanted to make was exactly that. There's nothing about what I told you as far as where we're headed with the process, the discovery, possible motion date at the end. There's nothing going on there that would stop a settlement between the parties in the meantime.
Oh, okay. Okay.
So it's not like it's not like the door to a possible settlement got closed this morning and it can't be reopened. I can guarantee Mr. Herzog would rather settle this than go through all the, do all the paperwork and file the motion. He'd much rather have a settlement and be able to close his file.
Yes, sir. Me too.
Okay. All right. So what my suggestion to you would be, contact those folks, whoever you're dealing with personally, and say, look, I just got off a Zoom meeting with the judge and the plaintiff's attorney. Plaintiff's attorney's waiting to hear from you people.
Okay.
Okay.
As soon as we get off here, I'll do that very thing.
I wish you luck. Anything else we can take care of today, gentlemen?
No, thank you, Your Honor.
All right. Gentlemen, be healthy.
Thank you. Too. You too. Stay safe.
Bye-bye.
I'm bringing Mr. Groen in. He's the attorney for Spikes. Well, for Midland Credit.
Got it.
Hello?
Lily Spikes, please.
Yeah, this is she.
All right, Ms. Spikes, Brian Oakley calling from the 34th District Court. I've got Midland Credit Management Company's attorney on my Zoom, and I'm going to call the case officially. Counsel, your appearance for Midland Credit, please.
Brian Gruen, Groen, P number is 56673.
Good morning, Mr. Gruen. I've got Ms. Spikes on my speakerphone. Can you hear her okay?
I can, Your Honor.
And ma'am, can you hear Mr. Gruen?
Yes.
Awesome. All right. So ma'am, this is a date and time set for a pretrial. And what that means is that it's an opportunity for me to get information about this file. So hopefully we can put it on the calendar and move it towards a resolution. Counsel, with that in mind, where are we at from the plaintiff's end?
Your Honor, we actually didn't even receive a copy of the defendant's answer, so I'm not for sure what she's alleging, but this is based on a Gardner White credit account through Community Bank. The amount of damages was $1,557.86. The account was opened in December of 16. Last payment was December of 2018 and was charged off in July of 2019.
All right, I'm looking in the file. It looks like Ms. Spikes filed an answer with the court September 9th we received it September 9th. And I made a note in the file. I have one of my clerks get that out to you, so you've got a copy of it.
I appreciate that.
All right. Real quick, I'm just going to take a look at it. All right, Miss Spikes. I'm going to paraphrase your paperwork that you submitted with your answer, and you let me know if I get it right or if I missed the ball. Okay.
Okay.
In essence, you're not denying that you owe money to Midland Credit. You've just got financial situation that doesn't allow you to pay that. Is that correct?
That's correct.
Okay. Counsel, I wondered, given that, I wonder if maybe I should provide a phone number so you can contact Ms. Spikes. Maybe you can work out some kind of consent judgment and then maybe jump back on Zoom. We can actually accomplish something today.
Or else you could just ask her if she's willing to enter into a consent judgment for the total amount. We with no installment payment terms, we're more than willing to do that.
I don't mind being the go-between. Ma'am, are you interested in entering into a consent judgment? Let me explain what that means. If the parties, in other words, if you and the attorney for Midland reach an agreement today, I can make that official, make it legally enforceable. And that's a consent judgment. And that means we're not going forward with any more court proceedings. You understand that?
I understand.
Okay. So at this point, are you willing to agree? And when I say that, I mean formally agree on paper that you agree that you owe the money to Midland and maybe set up some kind of a payment plan as part of the terms of that agreement.
Yeah, it would probably just be what amount I'm gonna pay because I just get Social Security, so I'm from month to month and barely make it through the month.
Understood. Let's do it this way. What do you think you could afford to pay on a monthly basis to Midland on this debt?
I have no idea. I probably would have to, like I do now, borrow money from family at the end of the month just to fish out my month of what I do owe out.
Okay.
I understand I owe, and
right.
I just have to do what I can. I don't know what else to do.
All right, counsel, I'm not sure how we can set up a consent judgment with payments if she, at this point at least, she can't commit to any amount.
I agree. We don't need the payment amount, but if she was willing to at least enter in the consent judgment, it sounds like if she's just receiving Social Security, it's not something we're going to be able to collect on anyway. So it's basically a piece of paper.
Right. Let me make a suggestion. We could draw up this consent judgment so you agree that you owe roughly $1,500, and I'll ask counsel to give me the actual number in a minute. But roughly you owe $1,500 to Midland, and we'll put terms in there that they can't do anything to collect that money for a certain period of time, just to give you some breathing room so you can try to get some kind of regular payment set up with them.
Okay. Counsel,
does that make sense?
I'm more than willing to do something like that, Your Honor.
What can you agree to as far as a hands-off periods to give her some breathing room?
Like 60 days, would that be okay with her?
Ma'am, 60 days give you enough time to try to get some ducks in a row? Well, You sure 60 days with the holidays and everything, that's enough?
Well, I'm not doing nothing for the holidays anyway, so.
Okay, okay. All right. So counsel, what would be that number?
Your Honor, the amount of damages per the complaint was $1,557.86. Our costs were $55 for the filing fee, $44.60 for the service fee, which totaled $99.60. So the total amount of the judgment is $1,657.46.
All right. Ms. Spikes, did you hear that total? $1,657.46.
Yeah, I have the paperwork in front of me.
Okay, all right. Do you have an email address, ma'am?
Yes.
All right. What I'm going to do, if it's all right with you, I'm going to get that email address. I'm going to ask Mr. Gruen to prepare that paperwork, send it to you. If you agree, just send him an email back that says he can sign your name to that document. Then he'll sign it on behalf of Midland. He'll send it to the court. I'll sign it, makes it legally enforceable, and then both of you folks will get copies. Can we do it that way?
Okay.
Would you provide me your email address then?
It's LSPIKES0723@gmail.com.
Okay, so it's your first initial, last name, 0723@gmail.
Yes.
Did you catch that, counsel?
I did write that, so I should have it.
Okay, Ms. Spikes, do you have any questions, ma'am?
No.
Counsel, anything on your end?
Nope, but just let Ms. Spikes know that I'll try to get that over to her by the end of the day. And once I get it back from her, her authorization to sign on her behalf, we'll get it over to the court.
All right, did you hear all that, ma'am?
Yes, I did.
All right, and any questions from you?
No.
All right, good luck, ma'am. I'm going to hang up the phone and wish you a good day.
Okay, thank you.
You're welcome, ma'am. Thank you, counsel.
Thank you, Your Honor.
I'm going to find out who Don Blair is.
Yep.
Good morning, Miss Blair. What case are you here on, please?
Good morning. I'm here for Barclays versus Mungo.
I do have her in the waiting room.
Is it possible to speak with her real quick?
In a breakout room?
Yes.
Okay, let me bring her in and we'll put you in a breakout room.
Thank you.
Good morning. I'm at Miss Mungo. I'm going to put you and the attorney, Miss Blair, in a breakout room so the two of you can speak, okay?
Okay, is this necessary considering we already have an agreement and I've already made the first payment?
That's why I want to talk to you real quick.
Okay.
Caitlin Harder,
Yes, Your Honor, I'm here.
how are you today?
I'm well, yourself?
Not too bad. What are you calling in on?
On sack strip towing, I'm standing in for Guy Conti.
All right.
We don't have the other party
Yeah,
in
I don't
there.
see the defense yet, but now we know who you are.
Yeah.
We'll put you back in the waiting room and wait.
Great, thank you.
Thank you.
Judge, I'm going to rename her before we stick her back
That's fine.
in. Just so I can,
Oh, I'm sorry, Paula.
that's all right. I'll bring
You
her
wanna
back
bring her back in?
Yeah. I can't, for some
Yeah.
reason,
Yep, I know. My finger was moving faster than my head.
okay. I'm just going to rename you and then I'll put you back in, okay?
Okay.
I've got Mr. Potron for Parks versus Nationwide and Mr. Betts. You want them in?
Hey, Paula, just to let you know, case 201557, Portfolio Recovery versus, Robin McBride, was a consent judgment yesterday.
Okay, so we're gonna go ahead and call that one.
Thank you.
All right. Thank you.
Thank you.
All right.
What time are they scheduled?
It was for 10 o'clock.
It's not on my docket.
Oh, I printed you a new one. It's probably on the judges though.
Okay, I'll let him know.
Okay, thank you.
Thank you.
No, he got a new one this morning too, so it won't be on there.
Okay, thanks, hon. Mr. Betts? Mr. Betts? Good morning, sir. Is that Potron or Pokron?
Cochran.
Pochran? I'm so sorry. Okay, hang on just a minute. Judge will be right with you.
Okay.
Trying to get Mr. Betts's attention.
Yeah, we're not scheduled until 10:30. Oh, there he is.
All right, gentlemen, Parks Downriver versus Nationwide appearances.
Morning, Your Honor. John Betts for plaintiff.
Lawrence Cochran for defendant.
Good morning, gentlemen. What do we need on this one?
If I may, this injured party has his own Wayne Circuit suit pending. And the insurance company's position is the injured person should get workers' comp benefits as opposed to no-fault benefits. And a summary disposition motion has been filed in the circuit court case. And both Mr. Cochran and I believe that that judge ought to decide that, because if that judge decides that the injuries involve workers' comp claims, that would dismiss our district court suit. But the only real twist is Judge Barry in circuit court is not going to conduct the hearing on that motion until, I think the date is February 2nd.
It's actually February 24th. It's Judge Snow, Your Honor, and we filed our motion in October, but it's been set for hearing on February 24th.
Wow. Okay. Is what it is. Doesn't make much sense to do anything on this before then, does it?
It does not. If you'll bear with us, that circuit court ruling ought to go a long way toward resolving our district court case.
Yeah, I don't know if the court wants to enter a discovery order or anything like that, but probably adjourn the pretrial till March, I think would be the best.
Okay. You want to do discovery in the meantime? I can do that.
Probably not needed until we decide whether we even have a case. Because if the circuit court says workers' comp applies, then our district court case is gone.
I think we do need to do some written discovery in the meantime, John. I just need to make sure we have all of your bills and records. And
I don't have a problem with that, with written discovery.
All right, so I'm just going to make a note. We'll adjourn this pretrial until after March 1. Written discovery pending in the meantime.
Thank you, Your Honor.
No, thank you.
All right. Good luck, gentlemen.
Thank you.
Thank you. We'll receive an order in the mail. or a new date?
You're not going to receive an order unless one of you drafts ones and sends one to me, but you'll receive a notice for that new pretrial.
Thank you, Judge.
Okay.
Understood. Thank you.
All right. Thank you, gentlemen. All right, ladies, are we ready on Barclays Bank versus Mungo?
We are, Your Honor.
All right, your appearance, counsel.
Helen Blair on behalf of case 62601.
And counsel, what do we have?
Well, we're here for our motion. We do have an agreement.
Good.
We did send paperwork to Ms. Mungo to sign and return. In my conversation with her, it sounds like she signed it and sent it to the court. I don't know if the court has documents signed by her, but not by me.
I told you I didn't sign it. The document didn't have a place for me to sign. I've explained that several times, but I did send it to the court.
Okay, what is that document titled?
It was a PDF titled my last name versus, or Barkley versus.
Okay, so you just forwarded an email?
No, I scanned in documents, uploaded it to the court's website.
All right, yeah, I don't have that in the file. So what are we doing? Are we doing a consent judgment? Are we doing dismissal, conditional, what?
Well, that is what we sent to her for signature that I don't have back yet. So
Which one of those two documents? Conditional dismissal or consent judgment?
conditional dismissal.
Okay.
That's not what you sent me.
Well, like I said, Ms. Mungo, we did send you some paperwork. We did send you some letters, but I can send it to you again if you don't have it.
So Judge, this is my challenge with this law firm. And I explained this to her in the personal room. This experience has been extremely shady. They'll say they've shared something or sent me something they didn't. And then they tell the court they couldn't find me, they couldn't do this, they couldn't. And every time I have showed up, even when they changed the date, I have done everything I can. I even have a settlement, I've made the first payment. And so now they're saying they sent something that they didn't. The only thing that I got was 2 copies of our agreement and a this is called the order for consent judgment. Those are the only things that I've gotten.
So that
You've signed nothing. And the first 2 didn't ask for a signature at all, which is what I actually sent to the court, because it's like, I'm literally stepping out of class right now to do this. And I'm just trying to pay the debt. I wasn't running from the debt ever. I was just trying to make an arrangement so I can pay the debt. And that's all I'm trying to do, and stop having to make these appearances.
Okay, was there a question in there for me?
Yes, what can I do to stop this? I've made
Sign the consent judgment.
Okay, and she said she sent something else, and I didn't, and I have not received it. She has not sent it. What am I supposed to do?
That's what I was referring to that was sent to you that needs to be signed and returned.
I'm sorry?
The consent judgment is what I was referring to that needs to be signed and returned.
Okay, so I need to send it to you, or I need to send it to the court? Because I prefer to send it to the court, because I don't trust your law firm whatsoever. And I don't want my signature documented. I don't want
So let's do it with snail mail, counsel.
I'm sorry, say it again.
Let's do snail mail. You can print out a consent judgment. You can mail it to Ms. Mungo with your signature on it and put the onus on her to sign it and get it to the court. And then that way we can avoid any more court dates.
Thank you. I will definitely take care of that. Thank you.
Counsel, does that work?
That works.
All right. So it's going to be a consent judgment, correct?
Yes.
All right. And I'm assuming you can get that sent out to her within the next day or 2.
Yep.
Okay. Okay. Ms. Mungo, anything else?
No, that's all. Thank you, Your Honor.
All right. Good luck, ladies.
Thank you.
Judge, I'm going to bring Sharon Greer in. I think she might be in the wrong room.
I pretty much guarantee that.
Good morning, Miss Greer.
Good morning to you all.
Good morning.
Good morning.
I think you might be in the wrong Zoom.
Well, I came in because the other day I was supposed to address a matter. Monday, I was supposed to address, no, Friday, DeAndre Gillette.
Oh, yeah. Yeah, we got to find that file.
Was going to hold it. Okay, because he
Yeah,
came to the court and they
Sharon-
told him that the court
Yeah.
was closed.
Explain to Paula what's going on that so she can figure out how we're going to do that.
Okay.
I'm
I
going to
will
step
do
off the
that.
bench because I got to do a search warrant.
Okay. Judge,
Okay,
hang on one second, Sharon.
okay.
Okay, Sharon.
Okay, madam, how are you?
I'm doing well, thank you.
That's good. Well, his name is DeAndre.
He was on our docket Thursday, wasn't he?
Yes, Thursday, the 19th.
Okay, how can I help you?
The judge ordered the capias, but he was going to order to hold it until Friday.
Okay.
Okay. And when I zoomed in on Friday, I forgot to do it.
Oh,
Because-
okay.
Because I was supposed to tell you all that he came to the court on Thursday and they told him that the court was closed. And that's why he did not appear.
Okay, hang on one second. Gillette.
That's correct.
DeAndre, okay. Do you remember what it was for?
It was for a pretrial. It's a domestic violence.
No, oh, domestic. How about aggravated assault?
Okay, I'll take that.
Okay, I'll tell you what I'll do. I'll find it and then I'll call you back and we'll decide how to take care of it, okay?
Okay, that
It's gonna
sounds
be a little bit. It'll be just a little bit, okay?
That's no problem, Paula. I'm 3 days behind. I forgot to do it.
Okay, that's okay. I'll go find it when we're done with our docket here and then I'll get back with you, okay?
Thank you so much. I appreciate it.
You're welcome.
Bye-bye.
All right, bye.
Did that lady ever call you that wanted to talk about?
You know what? I've got a message. I'm not sure who it was. Hang on, I'll try to call her.
Just put her on hold until we get done with the last one. If you can.
Okay. Thank you.
Counsel, do you have a phone number for Ms. Burrows by chance?
Let me look, just one moment. I was given the file this morning.
Oh, hold on, we might have her. Ms. Burrows, can you hear me?
Yes, I can hear you
Awesome,
now.
awesome. Okay. Sackstrup Towing versus Burrows. Counsel, your appearance for the tow company.
Caitlin Harder, for sex trip towing, excuse me, standing in for Guy Conti today.
All right. Good morning.
Good morning.
Ms. Burrows, today's the date and time set for a pre-trial. That gives me an opportunity to get some information about this file, so hopefully we can put it on my calendar and move it towards a resolution. Counsel, where are we at from the plaintiff standpoint?
From a plaintiff standpoint, Your Honor, we have the entire debt that's owed. You know, the vehicle was towed. I did receive an answer from Ms. Burrows regarding why the bill hadn't been towed. However, she would need to be billing her insurance company after she pays the debt that's owed to the towing company. That's where we're at today.
All right, so on your end, what are you thinking? Motion date, trial date? Do you need some discovery? And Ms. Burrows, I'll translate in a minute.
I mean, really, probably just a trial date at this point.
Okay, all right. And tow company okay with doing a Zoom trial?
That's fine.
Okay. Ms. Burrows, counsel's telling me that they're ready to set this case for trial, and we could do that on Zoom, just like we're meeting today. Understood?
Why does it even have to go through a trial when all they had to do was ask me for my my number for my insurance, and my insurance was paying all that. I'm just
I'll let Ms. Harder answer that.
Sure. Ms. Burrows, in order for your insurance to, and I don't know what insurance company that you have, but the way that it works through the towing company is that you actually have to pay the towing company for the debt that's owed, and then you would turn around and bill your insurance company for it. It's not the towing company's responsibility to actually bill the insurance company, as you were the listed owner of the vehicle.
Yeah, I was, but yeah, that sounds okay. Okay, well, whatever. I'm right at this time because I'm not even working right now. I just buried my daughter. I'm not. I don't know when I'm going back to work right now. I did go back to work from that accident. I went back in April of this year, and then my daughter died. She went into some water in Toledo.
I'm so sorry to hear
she
that.
died. I'm not even working right now. I don't know exactly when I'm going back to work. So I don't have a problem paying y'all and getting reimbursed by my insurance, because which really all I needed from you guys was to give me something that stated I owed this, and I could have got you guys your money. But the guy that called me and sent me the letter, he was being real nasty with me. So I just filled that paperwork out and gave it back to them.
Okay.
I don't
Judge,
even know
if you would,
what,
if you would, you know, just based on her situation, if you wouldn't mind actually setting this for trial, and then we can see if we can try to come to a resolution before then.
All right, because it sounds like what she needs is quote unquote an invoice from the tow company.
Yeah, that's exactly what it sounds like. And I have no problem speaking to the individuals at the credit bureau to make sure that she gets that.
Okay, so Miss Burrows, here's what my suggestion will be. I'm sorry?
Okay. I said I can get an invoice. I can send it to my insurance company, and they should be able to get you guys a check. I was never trying not to pay you guys, but I wasn't working.
Here's what I'm going to do. I'm going to have my clerk schedule this for a Zoom trial date. No sooner than 60 days.
Okay.
In the meantime, counsel's going to get her hands on an actual invoice, like the tow driver would hand you at the scene of the tow. Similar.
I'm sorry,
she's going to get you an actual invoice. So with that invoice, you can go to your insurance company and say, look, on such and such a date, I had to have my vehicle towed by this tow company. This is the money. If you can get the tow company, excuse me, if you can get the insurance company on board to cut you the check, then we don't have to have a trial.
Right. They usually don't. They usually just send it to them.
And that's fine. That's fine. Counsel's going to have to make up an invoice anyhow, probably at this point, so she can set it up so the invoice shows it's going to be mailed to her office. Counsel, does that work?
Yeah, absolutely. Yep, I have no problem doing that. Just so that Ms. Burrows is aware, though, that in the event that the insurance company does not pay us directly, that she still would be responsible for that debt to be reimbursed by the insurance company.
Understandable.
Understood, ma'am?
Okay.
Yes, ma'am. Yes, sir. Sorry.
It's all right.
I see her face, so I'm talking to her.
That's okay. I've been called worse than that today.
No, no, no.
So what we're gonna do is we're just gonna kick this can down the road for 60 days to give you ladies a chance to exchange some documents and get your insurance company on board.
Sounds good.
Can
Now,
I just
if-
verify with Ms. Burrows while I have her of her address? Is it
Yes,
89,
my address is
8909
89.
Parkwood?
Yes, it is.
Okay, and then your phone number, please?
And it's not 8909, it's 8908.
8908. My apologies, I misread it. And your phone number?
No, 734.
Yep.
734 320 5289.
320-5289.
Yes.
Okay, great.
All right.
Thank you.
Counsel, anything else today?
No, Your Honor, thank you so much for your time.
You're welcome. Ms. Burrows, do you have any questions?
No, sir. I don't.
All right. And ma'am, once again, my condolences about your daughter.
Same here.
Thank you. Thank you.
Stay healthy, ladies.
Thank you, Your Honor, you too.
Thanks. Paul, I still have one more file. Is Giller, that's what that is? Thank you. All right, then I guess we're done.
Hey, Paula.
Hey, Sandy, were you calling me? Mr. Horka?
Good morning.
Hi, are you here for the Giller versus Singh in Punjab?
Yes, representing defendants.
Okay. I'm going to go ahead and mute yourself, and I'm going to put you back in the waiting room for just a few minutes, okay? Hang on.
There you go.
Thank you. What, can I ask you what case you're here on, please?
I am okay. So I have a witness. My name is Dawn Giller. I'm here on case number.
I'm showing you as Ruth Mack, and then
yeah.
I have you in on another case for Don. I mean, another call for Don Giller. Are you on two different phones?
Yes, Ruth is my witness.
Okay, I'm gonna put you back on hold. Hang on.
Okay.
I'm gonna put you in the waiting room.
Okay.
All right.
Why isn't yours picking up?
All right, counsel, can you hear me? On Giller versus Singh?
Good morning. Yes, I can.
Counsel, can you hear me?
Yes, Your Honor.
All right, so Giller versus Singh et al., your appearance.
Good morning. Joe Horka, P75969, representing the defendants.
Okay, so we had this set for no progress. The last thing I've got is back in May. 60 days discovery. Go to neighborhood resolution. Set for in-house review. So what's happened with this case since May?
Your Honor, I filed a motion for summary disposition back in.
That was adjourned May 23rd. We adjourned that for 60 days written discovery and to try mediation. So what's happened since May 23?
Nothing to my knowledge, Your Honor, besides this pending motion.
And have you heard anything from Dawn Giller?
Not to my knowledge.
Right here.
Are you Miss Giller?
Yes.
Okay, so what's going on with your case, Miss Giller? Why haven't you done nothing?
I was waiting to get a response. They said that he was supposed to go to the it was a mediation neighboring council. I have not heard. I was waiting for paperwork. They said he had 30 days.
Okay, who's they and who's he?
His last attorney that was on the last time we had court.
Judge, do you mind if I make a quick phone call to my office?
I do, but I guess we have to.
Sorry, Your Honor. I'm just going to mute myself and take video off for a minute.
All right.
Ms. Geller,
Yes.
you can go ahead and mute yourself for just a few minutes. Well, I'll let you know when you need to come back in. Okay?
Okay. Okay.
And you can, I'm not going to put you in the waiting room. You can just stay right there. But I'm just going to mute on this side. Okay?
Okay.
Thanks.
You're welcome.
Mr. Horka? Mr. Horka?
Yes.
Okay, you're ready?
I'm talking with Attorney Gerder right now. He is the attorney who handled this back in May, and he just needs a second to.
All right, I'll give you another minute. Thank you. Mr. Horka?
Yes, thank you for your patience. I'm ready.
Okay, let me let Judge know.
Okay, counsel, I'm back.
Thank you, Your Honor. I appreciate that. I spoke to Attorney Brian Gerda, a colleague of mine in our office. Our filing cabinet, which contains all our paperwork for cases, was pretty bare on this. I had our motion for summary, our notices to appear, default judgment that we had sent in, but nothing related to mediation. So I called him to see if he had any contact with the plaintiff or the mediation services, and he couldn't find anything in his records being contacted by either party.
All right, so Ms. Giller, did you, I'm testing your memory, but way back when, did you receive a copy of the defendant's motion for summary disposition?
No.
All right, so counsel, my suggestion so we can get this case moving is renotice your motion, make sure the plaintiff gets a copy of it, and we'll have a motion here.
Ms. Giller, has your address changed at all?
No, it's the same one that's on file. The 15419 Woodworth in Redford.
I believe that's the address we sent our motion to, so I will send it to that same address again.
Remail it with a new notice, talk to the civil department to get your date. Ms. Giller, you're gonna have a chance to respond to that in writing, and you'll also have a chance to respond orally when we get together again for the hearing date. Understood?
Okay.
And I don't know if we've talked about this before or not, but a motion for summary disposition is defense attorney's argument that there are no material facts, no important facts that are in dispute, and based on the law that applies to this fact scenario, they're entitled to a dismissal.
I have a question about that because
you understand the process.
I'm sorry.
Your questions. Do you understand what I just said about when I explained how a motion works and what this is about?
To where I have to respond to it, yeah.
And I explained what this motion is requesting. Let me do it again. Motion for summary disposition is when one side asks the court to rule in their favor. In this case, it would be a dismissal of your claim against the defendant. A motion for summary disposition is saying that there are no facts in dispute. The law that applies entitles them to their relief. You understand that?
You know what? I did. And here is the paper that I dropped off to their office to where this was the submit. The day that I submitted it, it was February 28th, and I submitted 125 pages.
Ms. Geller?
Yes.
You're making this much more difficult than it needs to be. All I want to know at this point, do you understand what I just explained to you?
Yes, I do. And I did. I'm sorry. I did submit the disposition because when they sent the last paperwork, that was the response. I had 12. I had a table of contents of 12 different exhibits that were in that file.
All right. So you're telling me you already responded to their motion?
Yes, I did.
Okay.
Yes.
I'll just get it scheduled for a hearing then. Understood?
Yes.
All right. Anything else?
Judge, do I call the civil department and just set a date?
Correct. They'll pick a date and time. We'll do it by Zoom.
All right. Thank you, Your Honor. I'm going to make a note that she's responded and we're ready to go on the next date.
Yeah, and make sure you've got a copy of the response. If not, the clerks can share what you filed with the court.
Okay.
Ms. Geller, anything else?
You guys should also have a copy of it because I have 2 copies. I submitted one to the courts and another one to their, I submitted it to their secretary, Jamie Bazzi.
That the law firm you're referring to, ma'am?
Yes.
That's the secretary.
Okay. So, Ms. Geller, you'll be looking for a notice from the court about this next date.
Okay.
Anything else?
No,
no, that's it.
Thank you again, everybody, for your patience.
Okay. Oh, you're welcome. All right. Then just look for your notices. Have a good day, everyone.
You too.
You too. Thank you.
Paula, can you hear me?
Yes, this is Paula from Judge Oakley's office at the 34th. How are you, honey? Good, thank you. I'm just wondering if Mr. Friedman got a hold of Joshua Davis yet and decided whether they want. Oh, okay. We just got off Zoom. What? No, I just got off of Zoom. We just finished our docket for Zoom and I thought I'd give you a quick call. So I haven't checked my messages yet. Yes. Yeah. Well, I knew he was very, he's not the only one. I don't, mhm. I don't blame him for being annoyed, I'll tell you. Yeah, he blamed all that to me the other day.
Stephanie, I plan on trying to do it tomorrow. I'm just not sure how reliable where I'm gonna be, the cell service is gonna be. But one of my big things is, I have no idea and have not heard anything for months about where things are at for our, components for our raised bench. Hold on, yeah, I had the guy from, I met with the guy from Nelson Mills, who was on the site doing other work. He told me exactly what I thought I wanted based on their little mock-up that they did. I had heard spit since then.
Okay. Well, I can leave it for the same date and time, and I'm gonna put via Zoom on there. And then I'm gonna say, okay, per APA Gillis. Just to let him know that we did check, and she said it was okay. Bond hearing.
If they're done.
Okay. Okay, I got it. And then just please let Mr. Friedman know that we will do that Monday, the 30th. Okay? Absolutely. Everything will be, at the time and date will be the same. Only problem is it will be by Zoom. Now, do you have the Zoom number to call in? If for the PCC? Yeah, it is. But do you want me to give it to you just in case? Just for grins and giggles? Oh, trust me, I do, honey, but I like to, but I don't like to redo things 4 or 5 times, so I make sure when I'm on the phone this time. So, okay, it's 491-975-6074. Okay, and then I will let Judge know that as well. All right. Oh, you're welcome, honey. Thank you. And I'll go in and listen to those messages now. We started Zoom first thing this morning. Yeah, I am so sorry, but all right, sweetie. Thank you very much. You too. All right, bye.
I agree with that, but that's not, we're setting one just to make sense for us to do that. July of 19. So it's been at least 15 months. That means you could ask me more. That's still not. Hey, Bob, the meeting we had at the building with Gary
Good afternoon, Miss Jensen.
Oh my God. Hi. How are you?
Good, thank you. Can I ask what you're in the waiting room for?
You know what? I've been trying and trying. I can't even believe I've got a person. I'm trying to get into the courtroom. I don't even know who I'm supposed to see. I got a notice in the mail that said I missed a court date. I never knew I had one. And
Okay, hang on just a minute.
oh my God, thank you so
Last
much.
name is Jensen, Jensen.
Correct.
And the first name?
Cassandra, Cass.
Okay. Cassandra, I hate to tell you this, but you have 2 warrants out for your arrest right now. You cannot take care of them on Zoom like this. What you have, you failed to appear to a hearing back in October.
Again, you know what? I was in Florida.
What was set for October 15th for Judge Green at 9:40 in the morning.
Yeah.
What you're going to have to do is send in some kind of when you go on our website, they have a place where you can, it says submit a letter in writing. Go on there and explain the situation and tell them that you want to take care of the files and that you would like to get the warrants recalled.
Okay. Could you give me the case number or I've been trying
I
to fill
sure
it.
can. Are you ready? You ready?
Oh, 1 second, honey. I'm so sorry.
No, that's fine.
Okay. Yep. Go ahead.
It's 17-3715 and 17-3716. These have been hanging around out there since 2017. You have a drove while license suspended and a possession of narcotic paraphernalia.
Okay. Now, once I can fill that form out and they will contact me for a Zoom meeting or whatever.
They'll contact you. They may just submit it to the prosecutor. They may submit it to the judge first.
Okay.
But somebody will contact you.
I sure appreciate you. Thank you so much. I appreciate you. Have a great day. Bye-bye, honey.
And if you don't hear anything from them and you're starting to get concerned because you still have 2 warrants out there, my name is Paula.
Paula, thank you.
You're welcome.
All
Have
right,
a
honey. Have
good
a great day.
day.
Thank
Bye.
you.
Thank you. Can you tell me your name, please?
Nicholas Recruzi.
I'm just going to rename you. Okay. I'm going to put you back in the waiting room until we get all parties, okay?
Okay.
Thank you.
Thank you.
Good afternoon, Mr. Yaldo.
Good afternoon.
You're here appearing for pallets?
Yes,
Thank you.
you're welcome.
Good afternoon, Rossville Woods versus Vera. Okay,
Nick, you
where's
have
all
to
the
stop.
background noise coming from?
I'm at work.
Okay, you're gonna have to mute then.
We'll go outside.
All right, counsel, your appearance for Rossville, please.
Your Honor, Jeremy Yaldo, PA 2238 on behalf of Rawsonville.
All right, and are you ready, counsel?
I believe so, Your Honor. Last time we were here, I guess there was a dispute as to the amount that's owed. But I'm going to proceed to try to get a judgment for the balance.
Okay, and Mr. Vera Cruz, Ms. Maggard, you folks are ready?
Yep.
All right, let's call a witness, counsel.
Your Honor, I believe my client should be appearing. I think maybe in the.
I've got nobody in my waiting room.
Give me 1 second, because they know about this guy. I just spoke to them a few minutes ago. Give me 1 second, Your Honor. Sorry.
Go ahead.
Your Honor, my client's joining.
All right, who am I looking for? What's the name?
Her name's Ella.
Okay, I'm watching for her.
Thank you. My apologies. I gave her the wrong Zoom ID. I gave her the one that wasn't yours.
No problem. Ella Lyles, can you hear me? Looks like you're muted.
Yes, I can. I'm sorry.
There you go. Okay. First witness, Mr. Yaldo, is Miss Lyles.
Yes, Your Honor.
Miss Lyles, would you raise your right hand for me, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth today?
Yes, sir.
All right. You can put your hand down. Go ahead, Mr. Yaldo.
Ms. Lyles, can you please state your name for the record?
Ella Lyles,
And what is your position at Rawsonville Woods?
community manager.
Are you familiar with the books and records that pertain to the defendants of this matter?
Yes, I am.
As of today, do they owe a total past due balance of $4,857.67, including court costs?
Yes, they do.
And to your knowledge, is the defendant a minor in the military or mentally incompetent?
Not to my knowledge.
Are there any other pending legal actions between Rawsonville Woods and the defendants?
Not currently.
Okay, and is the property kept in habitable condition?
For the most part.
Okay.
Yes.
At this time, are you seeking to recover possession and asking the court to enter a judgment for the total balance of $4,857.67?
Yes, I am.
Your Honor, I have no further questions.
All right. Mr. Veracruz or Miss Maggard, do either or both of you have questions for Miss Lyles? We're going to do it one at a time if you do.
Yes, I do.
Go ahead.
Okay, so we got the records from her this morning on our past due amount, and the discrepancy I'm seeing is they were charging us late fees.
Hold on. I'm going to give you a chance to tell me your side of the story. This is the opportunity for you to ask questions of the witness, Miss Lyles. If you don't have questions, that's fine. We can.
Yeah, the question is why is there late fees on every single month when by the courts you shouldn't be charging late fees till August?
Miss Lyles?
I don't believe we started charging late fees till August.
On the paperwork that I received this morning, I got every month has a $75 late fee on it.
All right, is that a question, Miss Maggard? Because I'm not at testimony for the defense yet.
Sorry, no.
Miss Lyles, do you have a copy of your accounting?
Yes, we have a copy of the ledger. Jeremy has it and I have one too. Let me pull it up.
Okay, so the $4,800 number that you testified about a moment ago, does that include any late fees?
It does include late fees, and I'll tell you which month it includes it for.
Go ahead.
Hold on one second. Let me pull it up. It includes late fees for the month of August, September, October, and November.
And just so we're clear, that was at $75 per month for late fee.
That is correct.
Thank you. All right, Mr. Veracruz, any further questions for Miss Lyles?
Not currently. I don't have the paperwork with me. I'm at work, so I can't even see what everybody else is seeing.
Okay. Well, don't feel bad. I don't have it in front of me either.
Right.
Miss Maggard, do you have any questions for Miss Lyles?
I do not.
All right. Mr. Yalo, any other questions for Miss Lyles by way of redirect?
Yes, Your Honor. Miss Lyles, earlier I had stated that the amount past due is $4,857.67. Can you confirm that for me real quick? Based on the ledger that I'm just noticing now, it might be a different amount.
Because we don't have the court fees added into it yet.
Okay.
To be clear, the ledger amount does not include court fees, but the $4,800 number did?
No, the 4,800 does not include that. Because I'm showing on the ledger as of November 20th, looks like there's 2 payments that were made, unless I'm looking at a different ledger.
You're looking at a different ledger.
Give me one second. I'm sorry. I am. My apologies. Too many ledgers added on to this. Your Honor, I have no further questions.
All right. Well, I do. What's the number that the plaintiff is seeking? Because I don't know now.
$4,857.67.
Total.
Total.
Okay. All right, Mr. Veracruz, Ms. Maggard, any questions by either one of you to Ms. Lyles based on the redirect question from Mr. Yolo?
No.
No, sir.
All right. Any other witnesses from the plaintiff?
No, Your Honor.
Okay. Do you folks have any witnesses?
No.
All right. Do either or both of you want to testify?
As far as like, I don't get how this works. So What would I
Okay,
testify
you've never
to that-
watched the trial on TV?
Not really. I work and I don't watch TV.
Okay. Okay. I just find it hard to believe that an adult in America has never seen a trial on TV. All right. The way it works is I take evidence and testimony today and I make a decision. So is there anything you
Okay.
want me to consider before I make my decision on this case?
On the
Yes, I do.
Okay.
On the
And-
ledger, it says that there's been
Okay,
a-
hold on. Ms. Maggard, are you going to testify now?
Well, were you gonna say anything, Nick?
You can go first.
All right, raise your right hand, Ms. Maggard. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth today?
I do.
Go ahead.
Okay, so on the ledger, it shows a $75 fee in May and in June. Oh, yeah, in May, it shows a late fee, and it's so confusing. There's so many papers backwards. So in May, it shows a late fee. And I guess that's the only late fee, I guess, because they started back in August with the late fees.
Okay, so I think I'm going to restate what I'm hearing from you and just correct me if I got that wrong or not. What you're saying is you agree that the amount due is $4,857.67 minus that one late fee of $75 in May.
Correct.
Okay. All right. Anything else you want me to consider?
No, sir.
All right. Mr. Yallo, do you have any questions for Ms. Maggard?
I don't, I mean, I do have a question. Ms. Maggard, can you refer to June 1st on that ledger? Do you see that there's a credit of $75 for the late fee that occurred on May 29th?
I do see a credit. I just didn't know where that credit came from.
Okay.
These are new ledgers, so it's very
Yeah.
confusing.
Your Honor, to let you know that there was a credit issued on June 1st to offset that credit from May 29th, 2020. So therefore,
Okay, so
there were no
they were
late
charged $75 on May 29th, and then in June, that was credited because you guys realized you shouldn't do a late fee.
That is correct, Your Honor.
Got it. All right. Ms.
And Your
Maggard,
Honor,
does that
no
make
further
sense if you look at the math?
Yes.
Okay. All right. Anything else, Mr. Yaldo, for Ms. Maggard?
No, Your Honor.
All right. Mr. Very Cruz, do you have any testimony that you would like to share?
Yes. So
Raise your right hand.
I
Hold
haven't
on,
looked
raise
at
your
any
right
of.
hand.
Oh, yep.
Raise your right hand. Do you swear, affirm, tell the truth, the whole truth, nothing but the truth today?
Yes, sir.
Go ahead.
So I haven't looked at any of those paperwork, so that's why all this has been so confusing for us, because it's every paper we've gotten from them. I got 4 papers in September telling me $1,500 to $4,900. That's the biggest reason I was concerned of what was going on, and seeing credits 4 months after we were not supposed to take late fees. I could get it if March was a late fee and maybe April, but to charge us a late fee in May, it was just confusing. So that's the reason why I contested, just to see. Me, I'm kind of like the court. You got to
Makes
prove
sense.
it without a reasonable doubt. That
Yep.
I'm not saying I don't owe the 4,900 or whatever.
I understand
it
your
is.
confusion. Okay. All right.
Yep.
Anything else, sir?
Basically just to tell you that I've got money to pay today. I don't have the full amount because it's just a lot of money to come up with in this time, but I do have $1,500. So
All right. Mr. Yallo, do you have any questions for Mr. Veracruz?
No, Your Honor.
Okay. All right, Ms. Maggard, Mr. Veracruz, anything else from you folks? I'm going to go back to the other side.
basically, I just wanted to let you know that I would like to have, if we can keep going with paying, I'd like to have everything cleared up by January 1st. I know it kind of seems like a little bit of ways, but we're talking like $3,300 and another month's worth of rent.
All right, Mr. Yallo, any questions for Mr. Veracruz?
No, Your Honor.
And that would, I
All
would
right,
provide
anything
weekly
else?
payments from now until then.
Okay. Anything else from the plaintiff, Mr. Yaldo?
Your Honor, I mean, I would just ask that, if a judgment is going to be awarded, that we have a writ date of 12/4/2020.
All right. Any closing arguments?
No, Your Honor.
Ms. Maggard, Mr. Veracruz, any closing arguments from you folks?
No, I was just curious to what a red date would be. Is that like a final?
Writ date,
Oh, okay.
WRIT. That would be the
Okay.
writ of execution that the plaintiff files with the court, and that's the paper that the court officers actually post on someone's door right before they move all their stuff out.
Right. So that would be
So
meaning
basically,
like,
what he's asking for is full payment of the amount that I determine is due by December 4th, or they can take the next. They, being the plaintiff, can take the next step to move you out.
by December 4th.
That's what Mr. Yaldo's request is.
Okay.
Understood?
Yep.
Okay. Anything else from anybody before I make a decision?
Nope.
No, Your Honor.
All right. What is your monthly rent, Mr. Veracruz?
The monthly rent, I believe, is $512 plus water and trash.
Give me an idea what your average monthly is.
About $545.
It's due on the 1st?
Correct.
All right. Judgment of the court, total amount due, $4,857.67. A writ to issue on December 18, 2020, if $1,500 is paid today and the December run is paid on time. If either one of those payments is not paid in a timely manner, then the writ will issue on December 7th, which is a Monday.
So you're saying pay the $1,500 and December's rent by the
Pay the
5th?
15 today because you said you could do that.
Yep.
Pay your December rent on time so you don't get further in the hole. If you do both those, I'm going to give you until the 18th to come up with the rest of the money or move out.
Okay.
If you don't pay the 15th today or the rent in December, you're not going to have past the 7th of December before you got to come up with all of it or move out.
Right. Okay.
That clear enough?
Yep, I understand that.
Mr. Yaldo, if you could write that up, get it to the court. You can email it if you want to, and then I'll get a signature and get it out to all the parties.
Thank you, Your Honor.
All right. And Mr. Yaldo, you've got a number of other files that are scheduled for 2, right?
Yes, and just to let you know, I'm going to be adjourning majority of them. So
okay.
I have Patricia Hawley and Jennifer Fowler both in the waiting room.
All right. Ms. Maggard, Mr. Veracruz, any questions about that one, or I'll let you go?
No, sir.
Awesome. I have one question.
Nope.
Go ahead, sir.
So if I pay the 15 today and the December's rent by the 5th, as you're saying, you're giving us till the 18th. What if we needed like another 2 weeks? Is there?
That'll be up to the management. If the management's willing to work with you beyond the 18th, then that's, the parties can decide anything they want to.
Right. Okay. I just wanted to be in full understanding of everything.
I'm giving you a guarantee. As long as you make those 2 payments as we just stated, then they're not going to be able to get you out until after the 18th. They're going to have to file the paperwork on the 18th, and then the court officers come out.
Okay.
All right.
Perfect.
Good luck.
Thanks.
Thank you.
Counsel, give me just a minute. We'll bring somebody else in.
thank you, Your Honor.
Ms. Lyles, or Mr. Yaldo, are you keeping her on? for the rest of
If
them?
she wants to stay on, she's more than happy to. If not, because majority of her cases are going to get adjourned anyways, she doesn't need to.
You can call me if you need me.
Thank you.
Okay, I'll talk to you later.
All right.
Okay, bye.
Thank you.
Good one.
Can you tell me which cases are being adjourned while we're waiting on the judge?
Yeah, give me 1 second.
Miss Holly?
Yes.
Hi. Hang on just a minute. Judge will be right back on, okay?
Okay.
All right, thank you.
Give me 1 second. Hello?
Hello.
Yes.
Okay, Mr. Yaldo.
So, for
I asked,
Rossington,
excuse me, Judge, I asked him to get us the ones that he is going to adjourn for this afternoon.
All right, say that again. You asked him what?
He said he's going to be adjourning quite a few of these for this afternoon. If he
Okay.
could just tell us which ones.
yes.
Well, let's
So,
deal with Miss Holly now that you brought her in. Is she going to be one of the adjournments?
yes, Your Honor.
All right, Miss Holly, can you hear me?
Yes, sir.
Good afternoon. Counsel your appearance, first of all.
Your Honor, for the record, Jeremy Yaldo, PA 2238 on behalf of Rossington Woods.
Okay, and what are we doing?
Your Honor, so based on information that was provided to from my client to me, looks like Ms. Holly has been approved for the EDP, eviction diversion program. And so we're going to be adjourning this for 2 weeks. And hopefully we can get things squared away and possibly dismiss this case if Ms. Holly is able to take care of her portion, if there is a portion that needs to be paid.
Paula, do we have a date?
No, hang on just a minute, Judge. I'll call Sandy.
Let's see if we can't get you a date, Mr. Yolo. Tell me who else you're going to adjourn. Hang with us, Miss Holly.
Okay, I will.
Rossington Woods versus Jonathan Fowler. Rossington Woods versus Eric Machat. Rossington Woods versus Joshua Robinson.
Okay.
Rossington Woods, Justin Full of Love.
Yep.
And then Rossington Woods, Del Pettigrew.
All right, I'm assuming you'd like to get those all on the same date for all the same reasons.
Yes, please, Your Honor.
Okay, let's confirm that date with the civil department, then we can do that.
Thank you, Your Honor.
We got 12-1, Judge.
Your Honor, is it possible we can push it a week later just because my client's going to be out of town, just in case if I need her?
Paula can check that.
Thank you.
Judge, we can do it on the 8th. However, we're going to have to do it a little bit later. We do have 2 live exams that I know are not going to go because prosecutor's office.
What time?
We can do it at 10:30.
Mr. Yaldo?
That's fine, Your Honor. That works.
All right, Miss Holly, that work for you?
Yes, what day was that?
December 8th at 10:30 in the morning, and hopefully we're not going to need a hearing for you at all.
Okay, 10:30 a.m.
Yes, ma'am.
On the 8th. Okay, I got
I'm
it.
here a lot, but they're not gonna get me here at 10:30 at night.
I needed that, Judge.
All right. Anything else we can do?
Have
for
a
you,
nice
ma'am?
holiday.
You as well. Stay healthy.
I will. Thank you.
All right.
Bye-bye.
All right, council. So I guess at this point. Oh,
We have the Fowlers, both
go
of
ahead.
the Fowlers.
Bring them in. Yeah.
Oh, I'm in now, sorry.
Good afternoon.
All right. Good afternoon. Rossonville versus Fowlers. Council, your appearance.
Your Honor, for the record, Jeremy Aldo, P82238, on behalf of the plaintiff.
And folks, can you hear me all right?
Yes, Your Honor.
You can hear Mr. Yaldo?
Yes, Your Honor.
All right. Council, what are we doing with this one?
Your Honor, I would ask the court to adjourn this to December 8th of 2020 at 10:30 in the morning. Based on information that was given to me by my client, it looks like the Fowlers have been approved for the EDP, and we're just waiting to finalize the paperwork, and hopefully the Fowlers can pay their portion if there is a balance that's still owed.
That's the
folks, you understand that, and are you okay with it?
I have some questions regarding it, if possible.
Go ahead.
So, our portion would be 224, is my understanding, or 244. And what about all the late fees? Because there's $600 in late fees, and on the bottom of my email that I have from at Wayne Metro Cares, it says late fees were not allowed to be accrued during the COVID time period. So what happens to that $600 in late fees?
Mr. Yaldo?
Give me 1 second. Let me look at your ledger real quick.
Thank you.
You're welcome.
Because when we met with the courts, it was said that we owed $3,000. Now that Wayne Metro has gone over with the park, what the park sent, it's only $1,300 that's owed in back rent.
So looks like late fees were not charged in March. Looks like late fees were not charged in. I'm sorry, there was a late fee that was charged in. I'm sorry, not April, but there was a late fee charged in May, but that got credited back in June. And then it looks like a late fee was charged on June. We could credit that one. And it looks like you haven't had a late fee, or then you had 2 late fees in August, which is the appropriate time to be charged for late fees. Your Honor, if possible, what I can do is if Ms. Fowler would like to give me her number, I can call her and we can discuss the amount that would be owed.
Sure.
That would be great.
Okay, if that's so, if Ms. Fowler, would you be able to give me your number over the Zoom?
734
1 second.
26
734
262
262.
5303.
Okay, if you can, would you be able to give me a call tomorrow, because I would like to discuss this with my client?
Yes.
And just to make sure that my client and I are on the same page as far as the late fees goes, and then we can try to work something out. Okay.
Yes. And your number?
248
Yep.
971
Yep.
1430.
Okay.
All right.
Okay.
And we can also correspond, right, in email, so we all have everything in writing and not verbally, correct?
Yeah, I mean, after our conversations, we can reduce it to email.
Okay.
Okay. And then also just be mindful too that because of the next hearing date is going to be in December, that December's rent's going to be due in owing as well, and that it could be part of the judgment.
They said that they already the stuff submitted to Wayne Metro already had December's rent on it.
Okay.
It sounds like you folks are on track. Any questions?
I'm sorry, what time on December 8th?
10:30.
10:30. Thank you so much.
Okay.
All right. Good luck, folks.
Thank you.
Sir.
We have Joshua Robinson in the waiting room.
There we go.
Mr. Robinson, good afternoon. Can you hear me?
Yes, I can.
Counsel, your appearance for Rossonville Woods, please.
Your Honor, for the record, Jeremy Aldo, PA 2238 on behalf of Rossonville Woods.
All right, and this one we're adjourning as well, Mr. Yaldo?
Yes, Your Honor, my client had informed me that they had submitted their portion of the EDP application. So we're just waiting to hear back from the agency. So I would ask there would be a 2-week adjournment to December 8th at 10:30.
All right, Mr. Robinson, understood?
Yes.
Any questions?
No.
Okay, December 8th, 10:30.
All right, sounds good. Thank
Good
you.
luck, sir.
Thank you.
Thank you, Your Honor.
All right, counsel, we'll put you in the waiting room for a second.
I'm going to find out who iPad 2 is.
Yep.
Hello,
Hi, can I ask what your name is, please?
is Eric Machat.
Okay. And that was Rossonville Woods versus Eric Machat?
Yes.
Counsel, your appearance for Rossonville for Mr. Machat's file.
Your Honor, Jeremy Aldo, PA 2238 on behalf of Rossonville Woods.
And Mr. Machat, counsel has asked me to adjourn this matter until December 8th. I understand you're in the EDP program and we just need some time for the paperwork to hash out.
Yes, from what I understand, they sent the payment to the headquarters.
That is correct, Your Honor. So the payment got directed to the headquarters that's located in Colorado. So my client has been working with their headquarters to see if they had received the payment. And that's the reason why we're asking for this adjournment. And if somehow—
We got to find the money.
Yeah.
Okay.
Exactly.
Okay. All right. That makes sense, Mr. Machat?
Yes, it does.
All right. Any questions, sir?
Oh, no.
All right. You're all set.
All right. What time will this be again?
December 8th, 10:30 a.m.
All right. Same number?
Same Zoom. Yep.
Okay.
Yep.
All righty.
Good luck,
Well,
sir.
Thank you.
You're welcome.
That's all we have in the waiting room right now.
All right. Let's see. Give them a few minutes, see what happens.
Okay.
Your Honor, I do have another one that we're going to adjourn as well.
We do have Megan Kimbrough in the waiting room.
Is it possible if I can speak to her in a breakout room?
Let me bring her in.
Thank you.
Good afternoon, Megan.
Hi.
Hi, Jeremy Aldo, who is the attorney, would like to speak with you in a breakout room, okay?
Okay.
Hang on one second.
Yep.
Hello?
Yeah, aren't we normally closed on Good Friday?
Yeah, we typically are. That's not one of the assigned holidays, and I don't have a union contract to go by. It's not a federal holiday, and it's not one that SCAO directly take off.
So we're not closed this year on,
Well, I don't know. I have to talk to Judge Oakley about that. We haven't signed the holiday agreement yet.
all right, thank you. Yeah, I fucked up. Hi.
Hi.
Hello.
You guys are ready for the judge?
Yes.
Okay, give me 1 second and I'll get him on.
Thank you.
Oh my gosh, I'm so sorry. I'm gonna go check on that. What are you screaming for? Oh, screaming. You're not a dinosaur.
Well, someone's not happy.
I'm so sorry.
I just said, well, someone's not happy.
He thinks he's a dinosaur. He's obsessed with Jurassic Park, so he always gets super excited.
Okay, I just let Judge know he'll be here in just a minute.
All right, thank you.
Meanwhile, I am going to check on Mr. DePietro and find out what he's here for.
Don't press the buttons. Don't press buttons. Okay. That's how you do speech, huh? You see Rachel?
Oh,
Yes.
I just got an email today. Chris Bennett's retired as of tomorrow.
Oh my gosh.
Yeah, we're gonna miss him.
I'm finding out, Mr. Yaldo is ready with Megan Kimbrough, and I've got Tom DePietro. I'm just trying to find out what he needs.
Can you hear me now?
I can, Tom. Hang on just a minute. Judge, he what? Till 2:30. Okay, Mr. DePietro, I'm going to put you back in the waiting room. Thank you very much.
Well, thank you.
I'm sorry. This is Paula, by the way.
Hi, Paula. Don't be.
Okay, thank you.
Bye.
All right, Country Meadows versus Kimbrough and Spearman. Counsel, your appearance.
Your Honor, for the record, Jeremy Yaldo on behalf of the plaintiff, Country Meadows.
Ms. Kimbrough, can you hear me? Ms. Kimbrough, I think you're muted.
How do I unmute?
There you go. There you go. I can hear you now.
Awesome.
All right, good afternoon.
Good afternoon.
Counsel, where are we at?
Your Honor, so I did speak with the defendant and we had come to an agreement. Looks like we're going to enter a consent judgment as to Megan, giving her until December 4th to vacate the premise. But she's did tell me that she's going to be moving out by November 30th. And I want that as part of one of the order. If she moves out by November 30th, that my client will not seek monies for what's owed. So therefore, that's the agreement that we had put into place. And then I would just ask for a default as to the other defendant due to his failure to appear.
Okay. All right, Ms. Kimbrough, is that the terms you've agreed to with counsel?
Yep.
Wonderful. All right, he'll do the paperwork. He'll get it to the court. Counsel, you want to email it to her so she can give you permission to sign it, save us a little time?
That's if that's okay with the court, that's fine.
That's fine with me. Ms. Kimbrough, is that all right?
Yeah, that sounds good.
All right, so he'll send you the email version of the order. You just send him a reply email that says, fine, go ahead and sign my name to it. And he'll send it to the court for my signature.
All right, sounds good.
You want to give us an email address so counsel can do that?
Yes, it is absolutely. It's actually my my first name. It's Maegan, Kimbrough, Kimbro, or actually no, it's Megan K 18@gmail.com. All lowercase.
Okay, so Megan K Maegank 18@gmail.com.
Correct.
Okay, I'll get that right over to you.
All right.
Good luck,
Sounds
Ms. Kimbrough.
Thank you.
You're welcome.
You guys have a good Thanksgiving.
You as well, ma'am. So counsel, we're waiting for one more, and let me make sure of something.
Okay.
Yeah, I'm okay with the default because it's been, they were supposed to be in our waiting room 15 minutes early and we haven't seen them yet. So if you want to,
On which one?
this would be on BZ.
Oh, BZ, I'm gonna adjourn. My client did receive funds from the
EDP?
EDP. It's just that they're on vacation and so they don't know if satisfied the balance just yet.
Right.
So if that's okay, can we adjourn it?
Same date and time?
Yes, Your Honor.
Done.
Thank you.
All right. Have a great afternoon.
Thanks, you too, and happy holidays.
Same to you, counsel. Stay
Thank
safe.
You too.
Judge, what about full 11?
Yeah, I have full 11 Pettigrew left.
Those ones
Thank
should
you.
be adjourned as well.
Thank you. Yeah, thank you. Sorry, I had my headset muted while I was talking to the judge about it.
It's okay. And I'll see you guys tomorrow. I know we have a slew of cases for tomorrow, so
Thank you.
thank you.
See you tomorrow.
Good afternoon, people.
Morning, Judge. Good afternoon, Judge. Tom DiPietro.
Always morning somewhere, Mr. DePietro.
Yes, sir. Nice to see you again, by this way.
Same here. How have you been?
Pretty well, Judge. How about yourself?
Good. Oh, just living this Zoom dream, Mr. DePietro.
It's wonderful.
Better than a poke in the eye, but not by much.
Yep.
Gentlemen, your appearances on Moore versus Moore.
Ron Ruark for the plaintiff, Your Honor.
And Tom DiPietro for the defendant, Your Honor.
All right, and we've got both Mr. and Mrs. Moore joining us. Mr. DePietro, your clients?
I see that.
Okay. All right. Gentlemen, where are we at with this one?
It's the eviction hearing today, I believe, Your Honor. When we're asking for, we gave a 30-day notice more than 30 days ago. The property issue, the ownership has been settled. The James Moore Trust is the owner of the property. Glenda Moore is the trustee. Glenda Moore, I can bring her on anytime by phone. She's with her husband right now. And we're asking for an eviction. There's been no, it's not a rent issue, but just for the court's information, there's been no rent or anything paid on the property in the last 5 or 6 years.
Okay.
My client needs the property back. They need to sell it and for the benefit of the trust. So we're asking for the court for an order of eviction. If they need a little bit of extra time to get out, I've got no serious complaint with that. They could have until the 31st of December to get out.
Okay, Mr. DePietro, do we need a hearing date or are we talking about a consent judgment? Where are we at?
Judge, we demanded a jury trial on this case. There's a 30-year history between these parties. All is not as simple as it seems. Our initial complaint or defense is that the real party is not in interest. That is to say, Glenda Moore has not shown her ability to represent the trust in any capacity since Mr. Moore is alive and since Mr. Moore has not been adjudicated incapacitated.
Okay.
But admittedly, the trust would allow the successor trustee to step in the event of an incapacity. She is not a co-trustee. So the incapacity is not defined in the trust itself, and there's a pending probate court proceeding to have a guardian and conservator appointed for Mr. Moore, wherein his incapacity is alleged, but it has not been established judicially or otherwise to this point. So
Okay.
basically, we have someone who is purporting to be the party in interest, and they're not. Secondly, we would ask that the court await the outcome of the probate court matter because part of that relief sought is to have the trust supervised. And if that relief is granted, Ms. Moore, assuming she's attempting to act as a successor trustee, may have her rights eliminated or severely impinged because this eviction has been fought for 6 years.
Do we have a date at the probate court, Mr. DePietro?
January 4th, 5th, and 6th are the trial dates to wrap up the respondent's case, Mr. Rourke's case.
Okay, just out of curiosity, is that live?
No, we're Zooming.
Okay, okay, all right.
Your Honor,
go ahead.
I'm sorry.
That's all right.
I'll say I'll quit arguing right now if the court simply imposes upon the tenants a $1,000 a month rental payment to be paid in escrow into the court. And I'll stop arguing.
Well, Judge, that's a mighty tempting offer, trust me, but I'm going to have to object to that request for relief because we're not dealing with the appropriate party in interest. And it would be inappropriate if that issue is at issue to order my clients who have resided on the property for close to 30 years to pay someone who is not in a position to act on behalf of the title holder.
Well, actually, I said paid into escrow, into the court escrow, so it wouldn't be paid to Glenda Moore or to the trust at all. Now, if Mr. DePietro seriously wants to contend that Glenda Moore, who was named the successor trustee, if he wants to contend that she's not the appropriate successor trustee, I can provide a certificate of trust. I can provide a doctor's order that said that Mr. Moore is incapacitated. And by the way, we've all stipulated to his incapacity in the probate court proceeding. So for Mr. DePietro to raise that issue now, I think, is somewhat disingenuous.
Well, Judge, that's an inaccurate statement of the stipulation that was made in the probate court. That stipulation arose because Mr. Rourke did not want to produce Mr. Moore as a witness in the case. And because Mr. Moore had been previously deposed, I offered to agree to take the DEP and offer it into evidence in consideration of his claim that Mr. Moore could not testify because he was, quote, incompetent. But even Mr. Rourke will agree he has never seen an order saying so. He has never stipulated to the relief we requested in our petition for appointment of a guardian and a conservator and say, hey, he needs both. He hasn't said that. So the narrow stipulation he refers to does not relate to Jim's, quote, incapacity as that may be defined in the trust agreement. And it's only that incapacity which triggers Ms. Moore's right to step in as successor trustee because she is not a co-trustee. And I might add, Judge, counsel attached some pleadings to his complaint. It's interesting to note that the pleadings all the way through 2019, and I can tell you since 2013, when this matter originated, has never indicated a representative capacity for Mr. Moore. He has always pursued this claim in his own name, and that's never changed until this tenancy suit started.
But
So
the ownership, Tom, has been established. The James M. Moore Trust owns that property. So the escrow payment simply needs to be paid into court escrow for the benefit of the James M. Moore Trust, no matter who the trustee is. We can sort that out later if the court wants to, but there is a James M. Moore Trust and it owns that property. Therefore, I ask once again for an escrow order to be paid into the court of $1,000 a month, which is more than a fair price for this acreage and this house and all the supporting the adjoining buildings to be paid right into court escrow. I think that's very fair, and that way the trust will at least be getting some money paid into escrow.
I think, Judge, that subsumes or assumes that the probate court will not rule that the trustee, so-called, or the trust for that matter, has the right to collect the rent from him, because the supervision of that trust by a new trustee appointed by that court may state otherwise, because the issues in the probate court are also addressing whether Glenda Moore should have anything to do with removing these people from the property.
Would you agree with me? Would you agree with me that however it hashes out at the probate court, the question whether or not anyone is entitled or any entity is entitled to rent from Eric and Lisa Moore will probably be answered by that proceeding in probate court?
I would, Your Honor.
Mr. Rourke, would you agree with me?
Well, I believe it's been answered already, but yes, I would agree with that statement, John.
Okay, all right. So if we all agree on that, then I think what Mr. Rourke, you're saying is you just want some money coming into escrow. And we're talking about 2 months, December and January, because your hearing is not until after January 1.
It could be at least 2 months.
Exactly. Yeah. I mean, probate court could be adjourned or could be longer than 3 days, whatever. But that money would be held by the court pending my determination of what happens to that money. I might decide it's going back to Eric and Lisa Moore.
That's true.
Based on what happens at the probate court and whatever arguments that I hear in our case.
I agree, 100%. I agree.
Mr. DePietro, you agree or disagree with that?
I think you're stating a position. If you're saying you're ordering escrow, I would object, but I understand the court's rationale.
Okay, all right. Well, here's my option. If I don't order escrow, what do we do today? You've asked for a jury trial. I can't give you a jury trial today, and I can't do that until after January 1, as per the state court administrator's office.
Right.
So I think we're just kind of in limbo without an escrow order.
But if there's an escrow order, then of course my client calms right down, and so do I.
I'm sorry, I didn't
no
catch
money's
that.
being paid into escrow, then we can adjudicate the owner, not the ownership issue, but the right to the rent down the road. At least the money's coming into escrow. I'll remind the court and Mr. DePietro that there's been no rent money paid on this property for the last 5 or 6 years, even though the James M. Moore Trust has owned it every day of those years.
Right. Well, and I understand Mr. DePietro's position. Or at least I think I do. You can correct me if I'm wrong, Mr. DePietro. I think one of the arguments they're going to make is there was no rent required during that 5 or 6 years.
Absolutely not.
Right. So hold on. But if that's the way it hashes out, then the money I'm sitting on, Mr. and Mrs. Moore just lose the interest on it because I'm going to give it back to them.
I understand, Your Honor, but with a pending decision of the probate court looming before us, which would provide some finality, both perhaps to this action and certainly the probate court action.
Hopefully.
What is so bad about limbo for 2 months?
Because Tom, you know as well as I do, you're going to appeal it.
Because these people, this is their home for 30 years, Judge. This isn't some stranger who walked in and decided to rent the property. He has put up buildings. He's improved the home. He's run a business out of the place. So I think those factors and the impending hearing, which may resolve this issue, is enough to order us to end the limbo for 2 months.
And my concern, Your Honor, is that the litigation with Judge Gillis, which decided the ownership of the property, went to the Court of Appeals twice and to the Supreme Court at least one time, and it took 5 years to adjudicate it. And so my concern is that whatever decision is made in January gets appealed, and meanwhile, that piece of property is earning absolutely no income at all.
Which it didn't for 30 years.
Well, that may be true, but that issue's been decided in the Court of Appeals, where you made the very same arguments and they were rejected.
There's no harm resulting to the trust, Judge. It's as simple as that.
Well, there is. It's losing all this rent money, Tom. We could sell that property and we could be earning rent for the trust. And my trustee has a fiduciary obligation to make this property income producing for the trust and its beneficiaries.
Respectfully, Your Honor, I think that issue is one of the main issues of this case, whether she has any duty at all in light of her status in the case. But the point is that they are not getting the rent anyway. So how is the trust being prejudiced by kicking the man out of the place he's lived with his family and raised a family for 30 years when it's being put in limbo for 2 months?
We're not kicking him out. He just has to pay escrow. That's all. And like the judge says, he can pay the escrow. If the judge decides the money's returned to him, then he gets the money back. Otherwise, it's rent.
May I respond to that, Your Honor?
Sure, go ahead. I'm enjoying this.
I didn't mean to be directly responding to Ron, Your Honor.
That's fine.
The issue of whether or not this rent gets paid might be subject also to estoppel issues, because according to the paperwork they filed, they've owned this place with all final appeals in 2019. So what's the big deal? They wait 1.5 years to start an eviction proceeding? What's up with that? They don't like what's happening in probate court. That's why they don't.
I don't mind what's happening in probate court. I mean,
well, you just lost, excuse me, I don't mean to respond.
We lost a motion for directed verdict, okay? That could go on appeal too. There's no harm done by requiring the tenants to pay $1,000 a month into the court escrow. None at all.
I would argue, Your Honor, if I may respond, that the trust has already been harmed by sitting on this thing for 15 months. What's the rush?
We haven't been sitting on it for 15 months. We waiting for resolution of the cases, and this COVID thing came on.
I'm done arguing, Judge.
Okay.
I can see I'm just going to cause Mr. Rourke to keep arguing, so I'm going to shut up.
I'll shut up too. The court knows what we think.
Well, that's what attorneys do. All right, Mr. DePietro, I can't see where I'm going to prejudice your client's legal position by ordering the escrow, and I don't see there's any damage done because it's easily corrected if the probate case comes down the way you're thinking it's going to. So I am going to order $1,000 escrow paid to the court. I'll stress that. $1,000 January 1, $1,000 December 1, and this is. At any time, you can file a motion. If it looks like this thing's going to drag on for months and months, we can look at this issue again.
Very well, Your Honor.
I'm hoping that the probate court at least resolves some of your issues the first part of January.
As do we, Your Honor.
All right. So what I'm going to do is I'll ask Mr. Rourke if you'll prepare that order.
I will, Your Honor.
Email it to Mr. DePietro for his okay. Email it to me. I'll sign it and get it out. I'm just going to set this for an in-house review. So let's say 60 days out. Hopefully we'll have something from probate court at that point.
Very well, Your Honor.
Fair enough, Your Honor.
That's 60 days, a reasonable time frame, I assume?
I think so. I think Ron's going to rest his case in January, and
I am
much rebuttal. So give the judge another 30 to 60 days to decide it.
Okay. Who's your judge, by the way? Just out of curiosity.
David Braxton.
Okay. All right. Anything else we can accomplish today, fellas?
I'll submit the order to Tom first, Your Honor.
All right. Stay healthy, gentlemen. Enjoy your holidays, and happy Thanksgiving to the Moore family.
Same to you, Judge. It was good seeing you again.
Same here.
Thank you very much.
Ron, do we leave now or do they throw us out?
I'm going to kick you out, Tom.
If you need to call, Tom, if you want to talk, just give me a call.
Okay.
You've been kicked out of better places than this, though.
Do you want me to shut it down completely
Sure.
now? That
Yep.
was the end, so.